Hey. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston within and for the Commonwealth. Draw near, give attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin, and I am excited to be joined by two outstanding colleagues. To my right, Justice Massing. To my left, Justice Desmond. We will be hearing 6 cases this morning. The rules are as they always are. I might change them, but whatever, they tell me what the rules are. It's 15 minutes aside with no rebuttal. Why no rebuttal? I don't know, but we don't have rebuttal. So, having said that, and if either side is dividing its time, you should let us know, although I see only a single attorney on each side here, so that seems not relevant to our first case, which is number 22-930. And this is Convey versus Department of Corrections. And we will hear first from Attorney Phillips.
Good morning. Carlin Phillips on behalf of the appellant, Lori Convey. Your Honors, this is a case, an appeal of a summary judgment decision from the trial court denying our motion for summary judgment and awarding the Commonwealth summary judgment on a single Wage Act claim. There are primarily 4 points I'll talk about today, but I'll spend my time talking about the Wage Act primarily and address the other points at the latter part.
Can I just ask you a quick preliminary question? You're representing plaintiff Convey.
Yes.
And I understand the rest of there's one other plaintiff who has not settled?
After the trial court decision, there was an arbitration decision enforcing a settlement, and a number of the teachers signed on to that decision. Ms. Convey did not, and one other teacher did not. That issue was not before the trial court. It all arose during the course of the appeal.
Right. So you're representing Convey and the other person at this point?
No, Your Honor, there is still a certified class down below, so in theory, it's still a certified class. If we're going to address the issues regarding the release and decertification of the class, one of my positions is all of those issues need to be taken up in the trial court as to whether those releases were sufficient to waive Wage Act rights and how the trial court will deal with the issue of a certified class.
Do we know what that settlement looked like? Do we know what that alleged settlement looked like? Like, what is it that lured these other class members to sign this?
Well, what had happened, Your Honor, there was an arbitration on the underlying issue. The teachers lost. But prior to that, there were settlement negotiations on the eve of the arbitration. And the union thought they had an agreement. They had a second arbitration to enforce that. The court said the arbitrator said they had an agreement. So then, pursuant to that arbitration agreement, the terms of, I don't know if it's a settlement or a judgment. I wasn't privy to any of that. I only learned all of it about that after the fact, as did my sister counsel, because we weren't involved in the underlying arbitration. So there is a document that they reviewed, and then they signed an exhibit to what is a release. My understanding is they get 7 weeks of comp time.
Did your client sign that?
No, Your Honor.
It is in the supplemental record appendix, but as you point out, this happened after the appeal.
Correct.
Okay.
And there's been, well, I suppose it's interesting. I gather DOC has not made a motion to dismiss those members of the class on mootness grounds or whatever who signed this. Right, this is an ongoing class action appeal, and no one has taken any formal steps to make it anything else.
Correct, Your Honor,
Okay.
because it happened after the appeal. Our brief was already in, and they did their brief, and I assume we addressed these issues depending on the decision. It's an awkward situation. It's a strange procedural situation. There's no doubt about it.
I mean, and as it stands now, the case is dismissed in the
Correct.
trial court.
Correct. So we're in this procedural no man's land.
you.
Wait,
Sorry.
the case is dismissed in the trial court not because of the settlement, but because of the judgment. Okay.
Yes, why we're here today. Yes.
So the collective bargaining agreement that ran from 2014 until 2016, right?
Yes, Your Honor.
June of 2016?
Yes, well, the new one started it in January of 2017, but the school year ran till June of, the school year involved ran from 2016 to June of 2017. The school year at issue. Because there's the actual contractual year, then there's the school year, which always overlaps into the subsequent year, because school on the prior collective bargaining agreement ended in June 30th. Then they changed to a new fiscal year for 2017.
So hold on. So the prior one ended in June, the 2014 to 2016, is that right? Which one are you referring to as the prior one?
You're correct, Your Honor. It's styled as the 2014 to 2016 CBA. And in the record, it indicates in January 1st of 2017, the new negotiated contract took place. However, they were operating under the 40 weeks from the 2016 to 2017 school year. So you have school year, and then you have these contractual years. So one of the points we were going to make, one of our primary points, is that the trial court below looked at the MOU and the contract, but it failed to take the next step, was to evaluate the facts under the Wage Act.
And what contract is it that says 52 weeks refers to June 30th to September, whatever, as a summer break? Is that in the CBA itself?
Yes, Your Honor. And which brings me to one of the points I was going to make. Even the MOU doesn't discuss compensation. It doesn't discuss salary. It doesn't discuss the 40 weeks. It doesn't discuss the 52 weeks.
Did any members of the class not teach in 2017-18?
I believe there were some folks who did not teach. It was discussed. In other words, they may have left the employment and they received some pay, some pro rata pay.
So that's that's my question anyhow. If the 9 weeks in question.
Yes.
Let's start with that.
Yes.
Point to those 9 weeks for me.
Those 9 weeks would be from the end of June throughout the summer.
From the end of June till?
For the 2016-2017 year, the end of June throughout the summer, because our position is.
Till what day? September?
Yeah.
From September 2016.
What day? Do you know the day?
When the school started after Labor Day, I believe it is.
You don't know when the 9 weeks ends exactly?
The 9 weeks would, the pay period would be from the end of June for 9 weeks till school starts again. It was usually Labor Day, but under this new contract, there was an overlap, and they started them in July. Our position is the contract was for 40 weeks of service.
I understand. What if she had left employment June 29th? Would she have received any additional pay? Or would she just be out those 9 weeks?
Our argument would be the same. She didn't terminate. She provided all the 40 weeks of services. She'd be entitled to those wages under the Wage Act because they were earned. Just because they weren't paid yet, because the administrative conveniences paid over 52 weeks. If you and I have a contract for 40 weeks, and then I enter a second, but I don't pay you because I said I'm going to stretch out the payments and you agree, then we enter a next contract, and that one starts before your other payments are due.
Let me ask you.
The payments on the other contract and the new contract.
I think we're getting at the same thing, and I'm not sure I'm getting a clear answer. You say some members of the class did not work the following school year, completed the 40 weeks, and just decided I'm not going to teach 2017-18. Were they paid the 9 weeks?
Your Honor, those folks were not members of the class, so to speak.
Were they paid?
But they were paid some pro rata portion, is my understanding.
Why I don't understand what you're saying. What pro rata portion? They had a contract, at least according to you, that said, we get this, and then we get this vacation, or not vacation, doesn't even say that. We get paid over 52 weeks. Mm-hmm. Did anyone get paid over 52 weeks who worked the complete 40 weeks, who didn't then re-up for 2017? Did the DOC say, sorry, we've foreshortened your school year, you no longer get paid? Or did they say, oh, you're leaving, and so you won't be under this new contract, so let's finish up your 52 weeks of pay?
Your Honor, those exact facts did not arise in the course of this case. There's discussion of similar facts in the arbitration decision, but it is not for a 52-week, in other words, for that whole 52-week, 9-week period.
Can I ask, I'm on the same issue, same confusion. So how long has Convy been teaching? When did she start?
No, jeepers. I don't know, for a while, Your Honor.
For a while. So did she get paid from July 1st to September 6th, 2016?
July 1st. What are the dates again?
Before the 2016-17 school year started, she was receiving paychecks for July and August of 2016.
Before the 2016 school year started in September. Correct.
Yeah. I mean, so how do we know that? Why don't we know? Why isn't she prepaid? Why hasn't she been prepaid that vacation pay?
That was for the previous year's 40 weeks.
But how do we know that?
That's the way the contract was. That's the way it operated.
Although you said the contract doesn't say what the dates are.
Right, but that's the way these contracts operated. They would conclude their 40 weeks of service, 9 weeks would be paid to pro rata over the summer for administrative convenience. That's how they got paid. That's how the remaining paychecks were paid.
So would she have gotten paid twice?
No.
Why not?
Because we're talking about the week, for her 40 weeks of service, she was entitled to a certain number of pay. Then the new contract, the next year's 40 weeks of service, she's entitled to the salary for that year, for that 40 weeks.
So the spirit is when teachers have summers off, they still have some income. Is that why they're getting
Correct.
prorated 52 weeks, even though they're only actually, I'm going to say, working 40 weeks?
Correct. They had no obligation after that end of June 30th, obligation to work, to return to work. However, their paychecks were prorated and kept coming in. Their
Is there
contract
any,
essentially
is
ended.
there any evidence that this is for the convenience of the defendants? Certainly, the word vacation appears nowhere in here. I don't think it matters, actually, whether it's vacation or not. But is there any place you keep saying the 52 weeks is a pro rata for the convenience of the defendants? Is there any evidence of that?
The only evidence is that it was negotiated for the 52-week period. I mean, what it's been termed as convenience. Is there a person who testified to that? I can't put my finger on
Okay.
that.
But it
No,
serves the teachers well as well, right? I mean, the teachers don't have to set aside money during the first 40 weeks to carry them through the summer because they know they're going to be getting their checks throughout the summer nevertheless, right?
I agree. There are benefits to both sides of it.
Although they lose interest on that money by not being paid it while they work.
Correct.
Okay, so what were you going to say?
No, I think and it gives it to some of the other aspects, the union can negotiate timetables, but I don't think it can negotiate earned wages away. And I think that's why we have to do a two-part analysis, which is under the MOU and the contract, and the other analysis has to be under the Wage Act, whether the services were provided, those 40 weeks, and whether the salary was fully paid. That's the second part of the analysis the trial court never did. I think that it got stuck on the changing of the fiscal year and how that affected the calendar. But if you look at the MOU, it doesn't affect the payment of the wages. There's nothing in the MOU that says that. There's nothing in the calendar. It was implied by the arbitrator, but I don't think that was even the correct decision.
The teachers sign their contract. Do they agree that they're going to get paid X amount of dollars per year? $125,000 a year?
Yes, there is like most state employees, there's grades for your experience and what have you. You fall into a certain bucket and you get paid a certain amount of money per year.
Okay, and so what was Ms. Convey's?
I don't know what her salary was per year, but
Did she get
you
it?
move through the steps,
Did she get it?
except for the nine weeks.
So no is the answer.
She didn't get the 9 weeks, Your Honor.
She didn't get whatever that number is at the beginning of the year when she signs on. She didn't get that number.
Correct. The full number of her salary. And I don't think that's undisputed. They didn't pay it. It's in the record. It's undisputed that 9 weeks wasn't paid.
Do you think it makes a difference if it's characterized as vacation or payment or wages?
Well, I understand why they want to characterize it as vacation time, because they want to try to fit into that case, local, I think it's 289. But I don't believe it does, and nowhere in the CBA does it even reference the word vacation.
Nor the MOU, right?
The MOU doesn't reference vacation.
What do they call it? They call it mandatory time off? Or required time off, or what is it?
The plaintiff in her deposition said it was unemployed time. She said it, I think, succinctly. We don't accrue vacation. We don't have vacation. We have time when we're not working
Could she have collected unemployment during that window?
during the winter.
During that window, that 9-week window?
I don't believe so. I don't think she would qualify for unemployment. I'm not an unemployment specialist, but I believe the unemployment would say you're still under contract. You're just between contracts, between services.
I mean, they call it, it's under the supplemental agreement, it's called a summer break.
Yes.
And your theory, and you're saying, your theory is she worked, the school year started, her payment period was a 52-week period starting in September of 2016, not on July 1st of 2016, starting in September of 2016. And she worked, so she's entitled to get paid through the following September. And then what they negotiated, they curtailed that and they started a new pay period, so she's not getting paid those 9 weeks. That's your theory.
Correct. Her first contract was 40 years of service. She provided that. She did her job. She completed it. The union entered into a contract where they called her back to before the summer came, and so she was back on another 40-week work year. The fiscal year changed. All it changed was the dates. She didn't receive the 9 pro rata checks for those weeks that she should have. It's quite simple. I mean, it gets confusing because the new contract overlaps with the summer payments.
So she would have received 2 checks during that overlap period, is that right?
Yes.
If she decided to work in 2017, 2018.
Yeah, she did. She still works there.
But
If she didn't, if she walked away, she still wouldn't have received the full 9 weeks' pay?
Correct.
Okay, your time has expired, although it's a little complicated, so if there are further questions. I see none. Thank you very
I
much.
appreciate
Excellent
your time.
argument.
Thanks for your questions.
We will hear from Attorney McLaughlin.
Good morning, members of the panel. May it please the Court, Ann McLaughlin, Assistant Attorney General, on behalf of defendants appellees, the Commonwealth, and the Department of Correction. Appellees respectfully request that the Court affirm the judgment below, dismissing plaintiff's Wage Act claim because all vacation time that was due under the applicable agreement was provided.
Does the CBA refer to it as vacation time?
The CBA it uses different terms. It says
So
wages.
the answer is no, it does not refer to it as vacation time, right?
The 2014-2016 does use the term vacation. The MOU uses vacation and breaks.
Where does the word vacation appear in the 2014-2016 CBA?
In the 2014-2016 CBA.
And if you can tell me what page of the appendix
Yes,
I find
Appendix 61. And you'll see in subpart 2E, it refers to vacation. Now, the MOU refers to breaks. The MOU, which was signed in August of 2016.
I'm sorry. The 25 days of vacation, that does not refer, that is not the summer break. That's in addition to the summer break.
That's an addition. So.
Okay,
but
so if we had to read it, we'd have to say, I guess those 9 weeks aren't vacation.
Well, if you look at, if you look at the MOU, what is important is that 9 weeks at issue here.
Hold on, before we move to the MOU, I know we want to get to the MOU, but before we do that, I'd like to talk about the CBA.
Yes.
And so they clearly know the word vacation.
Yes.
Right? Because they use it for 25 days. How come it's not referred to as vacation in the 9 weeks that you're now calling it vacation?
It is referred to as time off. The MOU refers to vacation and breaks.
I don't care about the MOU. It's subsequent to the relevant contract. Could you answer Judge Desmond's question about 2014 to 2016?
That is correct. The term vacation is not used to refer to those 9 weeks. It's referred to as time off.
Okay, so now let's say I'm a person who works there.
Yes.
What do I have to do to earn that paid time off?
The 9 weeks.
Yes?
Again, in this instance, that time was not earned because the MOU.
I'm not interested
amended
in
the
a
CBA.
subsequent contract. We can talk in a minute about whether the union has the power to get rid of a wage that someone has earned, notwithstanding the Wage Act, although I think we both know the answer to that. So stop talking about the MOU. Let's talk about the 2014 to 16 CBA, which covers the 2016-17 school year. What did someone have to do to earn these 9 weeks of paid vacation, you're calling them, but let's say these 9 paychecks? What does someone have to do to earn them?
They would work the 40 weeks.
Okay, so now we have plaintiffs who worked the 40 weeks.
Correct.
And you failed to pay them the 9 weeks that they had earned. Why isn't that pretty much the end of the case? We can, and if we leave out your post-judgment settlement that actually mentions the Wage Act, which I don't even know if we can or should consider, why isn't that the end of the case?
Because two reasons. One, it's vacation time, which is treated differently under the Wage Act. It has to be due the employee under an oral or written agreement. And two, the vacation time.
Wait a minute, why isn't it due the employee under the written agreement? You just said it's earned after 40 weeks of work.
Because the MOU changed the
That's
CBA.
subsequent. I'm not interested in the union subsequently bargaining away someone's earned wages.
Well, I would disagree that it's subsequent because of the date it was signed. It was signed before the school year began. It was in August
Before
of
the
2016.
2016 school year?
Yes. In August of 2016, the union and DOC entered into that MOU that changed the school year and implemented that transitional school year. So the wages, the vacation was not earned because the work had not begun. The work had not begun performing, so it's the timing
So
of
now you're
that
making a new
MOU.
argument that this contract was amended.
Correct.
Where do I find that in your brief?
It is, we do note in the brief the timing of the MOU, that it was dated in August of 2016, prior to the school year beginning, so the wages were not earned. That is in our brief. And the MOU,
So Ms. Convey worked 40 weeks, right? Her understanding is I'm going to work 40 weeks, and I'm going to get my pay for 40 weeks spread out over 52 weeks, right?
correct,
That's her understanding.
correct, that's her
So she
understanding.
worked 40 weeks,
Yes.
and then too bad, so sad, we're not going to give you the other 9 weeks.
That is correct, because the union is empowered to negotiate the terms and conditions
They're
of
not
employment.
empowered
They did so
to bargain
prior.
away someone's earned wages.
Again, they're not earned because the MOU was
You just
prior to
told
the school
me.
year.
You just said they were earned. with
You
all
said
due
after
respect.
40 weeks.
If the MOU did not exist, is what I said. You were simply focusing on the CBA, and we weren't talking about the MOU. As a general matter, correct, you work the 40 weeks and you get the 9 weeks. But here, there was an MOU that was signed prior to the school year beginning, and so the wages were not earned. Again,
And
that
where
is what
did
the
it say,
arbitrator found
where did
below.
it say, not only the school year begins on whatever it is, July 17th or 1st, or I don't remember what day under the MOU, where does it say not only that, but you won't get paid the 9 weeks that you've earned by doing the 40 weeks?
If the MOU changed the schedule, so the
Yeah, but
school
it
year
doesn't-
ended.
I just don't understand this. I get that it changes the schedule.
Yes,
Let's take my hypothetical, a person who isn't going to work 2017-18. They just aren't. They're moving to California.
yes,
So they'll be done,
correct.
and they're operating under this CBA that says they'll be paid over 52 weeks. Or if you want to call it vacation, you can, but whatever. They're going to be paid, they'll have earned the 9 weeks at the end of the 40. And you say, well, we have an MOU that starts the new school year such and such day. And they say, that's great for you, and maybe you'll be able to hire someone to replace me, but I'm moving to California. Please finish paying me for my year. How can you, I don't understand why this MOU, where it says, no, you don't get paid because we're starting the school year early.
Again, one thing to make clear from the record is that the teachers were paid a salary. There were no monies that were owed
Only
to
if
teachers.
they worked. They were not paid the end of their 52-week salary. If they worked starting in 2017, you paid them for the 2017 school year. What does that have to do with it?
So, again, so what, the wages here are the 9 weeks of vacation that were not scheduled. They still received a summer vacation under the new school year that was shorter. But to be clear, all wages, all salary, was paid to the teachers. They were paid a salary that summer of 2017.
What
So
if
then-
they didn't teach in the 2017 school year?
If they did not teach in the 2017 school year, again, as members of the union, they do not
They
receive
would not be paid a salary, though, right?
If they did not teach, no, they would not be paid a salary.
Okay, so they wouldn't be paid for the full 52 weeks for 2016-17, and if they didn't teach, they wouldn't be paid for anything for 2017-18, and so you haven't paid them for 9 weeks. I mean, it doesn't seem...
Again, it's the agreement that the union reached with DOC prior to the school year beginning.
And it says in it, if you've already earned pay, it's extinguished, and instead, you'll get just the 40 weeks.
They had
Show me
not-
that in the MOU.
In the MOU, which is at Appendix 65, there were two MOUs. This is the one that changed the school year schedule. And this is what the arbitrator noted, that the 9 weeks were not scheduled because the school year ended on June 30th. Again, the teachers received all their salary. We're talking 9 weeks of vacation. We could certainly argue that the deal may not have been a good one, but again, that was the deal that was reached prior to the 2016-17 school year. And again, the arbitrator has already determined that the teachers were not owed that 9 weeks of vacation time under the CBA. And at the very least, the arbitrator's interpretation of the CBA is entitled to substantial deference. So again, the timing is important. The union, as we know from the Paris case, is empowered to negotiate the terms and conditions of its members, including the timing of vacation or salary, any other terms and conditions. Again, this MOU was agreed before the 2016-17 school year, and it shortened the school year to 40 weeks. So as the Superior Court noted below, Ms. Convey can call it whatever she wants, but at the end of the day, we're talking about 9 weeks of vacation. And again, this is what her union bargained for.
Would you say that was earned vacation time?
No, because the MOU, which amended the CBA, was signed before the school year began, before the work was performed. So it was not earned.
It doesn't say anything about what the 2016-17 teachers will be paid, does it?
It does not. It just
Okay.
provides the date and does not provide that 9 weeks of vacation, which is the subject of the plaintiff's
You can call it
wage
vacation. It's earned time when they will be paid, even though they're not working,
Correct.
okay?
And under the Wage Act, vacation is only actionable if it's due under an oral or written agreement.
Yes, the written agreement is the CBA, the 2014-16 CBA, that says they'll be paid over 52 weeks, and frankly, that doesn't call this vacation time.
It's not only the 2014-2016 CBA, it's the MOU that has incorporated and amended the 2014-2016
Well, this is
CBA.
the first time you're making that argument, but even if it does amend it, I don't see where it says, oh, you don't get paid. I just don't see
No,
that.
there's no salary that is owed to the teachers. What the MOU does is it changes the school year, and it ends the school year on June 30th. So that's why that 9 weeks of vacation from July 1st to September 6th was not scheduled, because the new 2017-2018 school year began. They did receive vacation that summer. It was shortened, and then they received additional vacation during the 2017-2018 school year.
What
So
if
still
they
received the
didn't
12 weeks.
teach? What if they ended their work for you
Yes.
when the school year 2016-17 ended? You keep saying they got this, they got that. They did not get it for the 2016-17 school year. If they continued to teach, then they got something under a new agreement
Correct.
that apparently, you say, truncated what they would get under the 2014-16 CBA. It doesn't say that's what it does. It just says there's this new school year. If someone walked away and said, I'm moving to California, you wouldn't have paid them the full amount for the school year. Now, you say there's an MOU, but they're walking away. They have nothing to do with that agreement. They're operating under the 2014-16 agreement.
Which is amended by the MOU. And again, this is why the arbitrator found that those 9 weeks of wages were not owed under the CBA.
Who signed the MOU?
The union signs it and DOC signs it.
Not one of the employees, not
No.
the employees.
Again, the union can enter into, again, the union is empowered under Chapter 150E.
It can't bargain away earned wages.
That is correct. But again, they're not earned because this is prior to the
You said
school
they
year
were earned. You
beginning.
said that to earn that time, you had to work 40 weeks.
Under normal circumstances, had there been no MOU, but the MOU here.
But the
amended
MOU
CBA.
can't bargain away their wages.
That's why the timing is important. It was in August of 2016, as the arbitrator noted.
But doesn't the MOU effectively cancel the 9 weeks that they earned? I mean, doesn't,
Again, they didn't earn it. Does it
No,
take?
hold on.
Does it take away the 9 weeks? Yes,
she worked 40 weeks, and
correct.
she was supposed to get paid over 52 weeks.
Yes.
So those 9 weeks, how can they not be earned?
They were not earned because the contract occurred prior to the work being performed.
Forget the contract. From 2004, the original CBA said you work 40 weeks, you get paid over 52 weeks. She worked 40 weeks, and so she would have earned, forget the MOU, she would have earned her pay prorated over 52 weeks, right?
Correct. And she received her salary. She wasn't owed any salary. What she didn't receive is the 9 weeks of vacation. That is correct.
And so, in an instance where she would have actually received 2 checks, she would have received pay for the summer and pay pursuant to the new school year, the new contract, the DOC gets to pocket that 9 weeks of pay that they would have paid out.
That is certainly a way of looking at it. Again, this is the agreement that was reached, and we can argue that it's not a good deal. But
Is the
union-
memorandum of understanding part of the 2017 to 2019 contract?
I'm sorry, is the MOU?
Yes.
Yes.
Part of the 2017 contract.
Yes, it's
So it
incorporated.
doesn't modify the 2014-16 contract. It's part of the new contract. I don't know what day it was signed, although this, at the back here, it does say, on page 70, it says June 27, 17,
That's the
which is
sec-
after the work was done.
That's the second MOU. If you look at the Appendix 63, that is the first MOU, which was signed in August of 2016.
Wait, but the schedule you pointed me to that shows the new schedule is on page 60.
65. That is,
No, it's not supplemental agreement T1?
so there's the first memorandum of understanding is on Appendix 63 through 65. That is what was signed in August of 2016, and we know that date from the arbitrator's decision. Then after that
You see the
is,
signature page on that memorandum of understanding?
yes.
Is there a date on it?
There is not a date on that, so that's why it's important to look at the arbitrator's decision, that the date was August of 2016. Also, at looking at the text of the MOU, it is clear that it's prior to the school year beginning. You can see in paragraph 1 that it refers to no later than October 31st, 2016. But again, both the Superior Court and the arbitrator noted that that was entered into in August of 2016. I see that I do have just 9 minutes left, or 9 seconds. I wish it was 9 minutes. Again, because the Wage Act only provides that wages with respect to vacation are due under an oral or written agreement, here the agreement, which was signed prior to the school year, did not provide for those 9 weeks of vacation. No salary is owed to the teachers, therefore, the
And this
Superior Court's
argument
decision-
doesn't appear in your brief.
Your Honor, the idea, this
The
argument is in our
argument
brief.
doesn't appear in your brief.
The argument that the wages were not earned because the MOU was signed before the school year is in our brief.
Where?
It is on page 26.
Page 26. Go ahead, Judge.
Do you know if there was a reason why they don't call it vacation time in the 2014, 2016 CBA?
I don't.
You think there's a reason for that?
I don't think there's a reason. Again, they use the term time off, breaks. I don't think there's a
They use
reason.
vacation in another area of that same contract. So why don't they call this time vacation time?
I don't know. Again, it's a distinction without a difference. I think it's time off. It's time that they're not working. And that term vacation is not defined in the Wage Act, so it should have its plain and ordinary meaning, as the Superior Court had noted.
Okay, thank you very much for an excellent argument.
Thank
I see
you.
no further questions. The case is submitted. The next case we will hear is an impounded case, and the attorneys are reminded not to use the actual names of the parties, pseudonyms, or mother, father, child are acceptable instead. It is number 23668, Department of Children and Families versus Mother. And if everyone's ready, we will hear first from Attorney Cohen.
May it please the Court. David Cohen on behalf of the appellant mother. This Court should reverse the adjudication of unfitness and remand the case for a plan of transitioning the child, mother's daughter, back to her. because the trial court erred here in improperly focusing its analysis on the wrong child and the wrong facts here.
Do you dispute any of the conclusions of law?
As clearly erroneous, no, Your Honor. No, there are some, there are some things built in that do have thin, I would say very thin support, but I won't dispute them as clearly erroneous. For example, let me go to the theme here. I mean, these are different children in different situations, and we have the law here that the court, this trial was supposed to be about the 2+-year-old daughter, not the special needs infant son. And the court really got off track and conflated some of these things. And the timeline is a little bit tricky.
I mean, it's not irrelevant, is it? The mother's ability to care for the infant, it's not irrelevant to her ability to care for the
Mother will
child.
not say that the court made an error in admitting any evidence of the other child, of the special needs infant, and how the mother cared for her. So no, it's not completely irrelevant, but it is. It does not meet the legal standard of finding clear and convincing evidence that mother is unfit for this child. And there are a number of reasons where you scratch the surface here, and it falls apart. Let me just, if I can, look at some of that. I mean, right, this child had no developmental milestone. It was meeting developmental milestones, does not have special needs, was born in October 2020 and came home to mother, was alleged to be a substance-exposed newborn. A mother admitted to smoking marijuana during her pregnancy, but did not test positive for marijuana or anything else, and neither did the mother, and was with the mother for 5 months. It's a very different situation than the child who's born much later in the case, in August 2021, who failure to thrive diagnosis, something like 3 to 4+ months premature, in the hospital in the NICU for 3 months, a feeding tube, special gastrointestinal requirements.
Understand, recognizing that the burden is on DCF, the department, understanding that, what do you point to that points to fitness with respect to the mother in this child, the subject child today? What do you point to for fitness?
Well, that's right. It's not mother's burden.
I understand that.
Okay, so a number of things. I mean, substance use in the sense of anything other than marijuana was off the table. The trial court found that mother submitted sobriety by the time of trial, et cetera. The alleged medical neglect, again, this is where the court conflated things. With the special needs child, if mother didn't bring the child to an appointment, 3 days after discharge or the week after discharge, this child needed to be fed
So if the
5 times a
subject
day.
child gets very sick,
I'm sorry?
so if the subject child gets very sick, then maybe she's unfit to have that child. But so long as the child is healthy, she is fit?
No, Your Honor. The subject child did not get very sick. The subject child did well, mother did well.
What if she gets sick?
Well, that is not the facts of this case.
No, it is the fact of every case. Children get sick.
Oh, you're saying, okay, this child needs to be taken to the doctor.
Or hospital.
Hospital.
Yes.
There is almost no evidence that this child got sick in that sense, and mother
I'm
had
not
sick.
asking about what happened before.
I mean, just
So prognostically, you're asking.
But you're saying that the fact, there's evidence, right, that for the subject child, the mother missed 8 appointments when the child was 1 and 2 months old, or 2 and 3 months old, right?
Yes, she
But you're
missed
saying-
some
but you're saying
appointments,
that-
but she
that
made
doesn't-
others.
Right, and you're saying that, but that doesn't matter, though, because the child was okay, was well. It would have mattered to the younger child, but it didn't matter to this child that she missed the 8 appointments. I mean, is that...
Well, there was no harm to this child in these circumstances. I'm not saying it couldn't be ever harm,
But that's the question, right? The question is, at the current moment, and this is not a termination of parental rights question.
Correct.
At the current moment, is this mother fit to have the child? And if she can't follow, and obviously there are other issues as well, but if she can't adequately provide medical care for the first child, the subject child, even though the subject child has not been harmed yet by that inability, And if with a really sick child, she also doesn't seek appropriate or follow appropriate medical care, isn't that at least evidence that she might not be fit to have the first child until somehow this ability to obtain proper medical care, go to appointments and so on is addressed?
It's not clear and convincing evidence here. And if I may, just so I make sure I understand your question, you're basically asking at the point of trial now, after all this has happened, removal, services, mother-to-daughter services, prognostically, what's the judge to make of it? Can't the judge consider?
Yes.
That the judge can consider that mother may have had some, let's call it lack that ideal parenting, should have brought the child promptly into appointments. Now, the mother did bring the child at the very beginning to some appointments. I'd point to Exhibit Appendix 69. There's a 51A that showed mothers brought the child in on November 8th, November 11th, and November 16th. This is within a few weeks after the child left care. Then this child, her need for a visiting nurse and early intervention basically went away quickly, and mother was taking care of the child. Let me try and switch it because I think it will answer your question, because there's medical neglect and then there's the substance use and the marijuana allegation, and I think those also get conflated in a way that is...
Let me ask you about the marijuana use. At one point, mother had a medical marijuana card, right?
Yes.
Okay, and then that got, I'm not sure what the right term is, terminated, canceled, revoked?
Ended in New York. She renewed it here in Massachusetts before this child was removed. She had the medical marijuana card when she used the marijuana when the child was removed. She bought the marijuana from a friend instead of going...
A medical marijuana card doesn't authorize you to buy street marijuana.
It does not, Your Honor. The mother conceded a mistake.
And there isn't a single finding of fact that she ever went to a dispensary, although I'm not saying she didn't, but there's nothing in here about it. How does her medical marijuana card bear any relevance to, maybe if it means a doctor has said she needs medical marijuana and I am prescribing it for epilepsy, then it tells us something about marijuana itself. But she's not using the card in any of the circumstances we see. She's buying drugs on the street.
That's not correct, Your Honor, based on this record. There's one instance of her buying drugs on the street in this record, and that's when the child was removed in March 2021.
That's when it was laced allegedly with cocaine or something and she passed out?
That's correct.
At the time that the subject child was coming in reeking of marijuana, did she have the card?
As far as I know, yes. There's no evidence to the contrary, that the card was revoked. If I may, I would also, that's the issue with this marijuana here, is the judge found, that mother was smoking marijuana still, well into the case after, the child had been removed and, returned to her for overnight visits, and that was a problem. Now, there's a problem with that conclusion. Well, in a couple different ways. One, the idea is, she did this in a way inconsistent with her medical marijuana plan, bought it from a non-licensed dispenser, bought it from someone else. No, there's no evidence of that happening later in the case. There was the one instance that she was doing it without anybody there to watch the child when she's under the influence. I would refer the court, and I didn't put this in my briefs. No,
that happened. Didn't one time she did it and the brother was there, but he was asleep?
It's the same time, Your Honor. That all is in March 2021. I would point you to Exhibit Appendix 428. Mother was living with various relatives, etc. Her cousin, EA 428, was living with her in April 2022 when she is about to be reunified with this child. She's having overnight unsupervised visits. Her cousin was living with her. There's no record evidence that the child was, when she was maybe using marijuana on the porch, because there's an inference, she must have been using marijuana in the apartment, even though
Is that what common sense tells us?
Well, the social worker testified, we were concerned about the car. The smell of the marijuana came from mother's car. And
Tell me about times it's a good idea to smoke weed in a car.
I don't know whether she smoked weed in the car while the car was moving or the child was in it.
Okay, so it's either a parked car and she's in there, why? So that the weed will be more powerful and the smoke will be kept in? Or she's driving and she's smoking weed?
Your Honor, if I may, I'll respond in this way. The court also found that marijuana contributed to this child being born prematurely. okay? There's no expert testimony about any of that. There's no real evidence.
Against medical advice, she smoked weed during the pregnancy.
Yes, but
So never mind the prematurity, how about just the injury to the fetus?
well, there was no significant injury to the fetus in the sense of the child was born healthy. This is not fetal alcohol syndrome. This is not where the mother was drinking alcohol to excess at the wrong point in the pregnancy.
But your position isn't that the medical advice not to smoke marijuana during pregnancy is wrong.
No, my position is that people disregard that sort of advice. Cigarettes. There are mothers who smoke cigarettes. Their babies are probably born premature and maybe not in the best
Low
of health.
birth
They
weight,
maybe shouldn't do that, but that doesn't make them unfit. We don't take their kids away.
I understand. Didn't mom explain that her medical provider advised her not to stop smoking marijuana while she was pregnant?
Mother testified to that and the court discredited. Yes, that's correct. So,
And so what was the motivation to testify to that, if you know?
what was mother's motivation to testify in that
Why
manner?
would she say that?
I can't speak to that. I don't know. I think mother did have many different providers. She went back and forth to New York, et cetera. I don't think it's clearly linked that it's the same provider that mother was testifying about, but I can't speak to.
Moving away from the marijuana for a second, what do you say about domestic violence?
I would say several things. Domestic violence was not a central part of this case when it came in at all. And just to prove that to you, from March 2001 to at least March 2002, there were no domestic violence-related tasks. They were not even a part of mom's action plan. That's finding fact 116 to 117.
Did she have housing that was somehow associated or connected with domestic violence or provided by that?
And that is an unusual and interesting part of this case. She did have housing at multiple times throughout this case, connected with domestic violence shelters, but it was essentially an independent living unit, not a group shelter associated with classes. It was sort of an independent living unit. She had a personal care assistant with her because she had epilepsy and diabetes and medical needs. And so she apparently was not obligated to take DV classes during the general housing situation. She ended up taking and completing them as we approached trial. But in terms of domestic violence, this was barely on DCF's radar. There's one finding of fact, I think that's finding of fact 87, which is just before this child was removed, that does mention obliquely, mother's having trouble at the apartment with the child, there's noise from the neighbors, she's playing the music too loud, that kind of thing.
When was Mr. A incarcerated for domestic violence against her?
Approximately August 2022,
So after this subject child was born?
well after this subject child was born.
Okay.
And I mean, I would say also with domestic violence, Justice Desmond, that DCF could not have been too worried about domestic violence as late as April 2022. This is when mother has taken the special needs infant home, even after all the time in the hospital. She doesn't have her daughter back, this subject child, but she's well on her way towards reunifying with that subject child. I mean, DCF said we want to reunify you within the next few months. She's increasing her visits. She has unsupervised overnights. If DCF was so concerned about domestic violence throughout this case, in April 2022, barely 6 or 7 months before, she's having unsupervised overnights. They would never have given those to her. So it's not that domestic violence is utterly absent from this case, or that
All of her relationships, I think the judge found, had domestic violence in them.
yes, but there had been none here for 6 months. I know that.
Let me ask you this. The judge also found that reasonable efforts hadn't been made toward reunification and ordered some corrective action. I know this happened after the events of the trial. Have those remedial steps begun being taken?
Well, those are outside the record, Your Honor.
I understand. I'm just asking.
I believe they have been, but I don't know exactly which amount. Let me just speak briefly, if I may, to visits here, as I see my time is about to expire.
Oh, you can talk for a minute.
Oh, all right. So, I mean, in terms of, there are many complexities of this case, but I think we've covered a number of them. In terms of visitation, mother's going to be criticized, well, you didn't go to visits very often. She went to visits consistently every week from March to September 2021. And then it tailed off for a while, and then again, it ramped up. Her visits ramped up by April 2022, and then the other child was removed from her, and then things fell apart.
Were there instances, or at least one instance, where she elected not to visit with the subject child because the infant child couldn't be present? And so she canceled,
Yes.
So she canceled the visit with the subject child?
Yes, and in that case, DCF had moved the visits to Wakefield from Boston. So transportation was an issue.
But she would have gone if the other child had been there.
I think we can understand that. I would just say, in the whole visit, there was a lot of back and forth here about visitation. But I would point to the judge's finding 153, where the judge basically says, well, mother was inconsistent, and, you know, she canceled visits for this reason, transportation, she didn't want them to happen. And the judge says, well, that's mother's excuse. But apparently for DCF, it was okay to cancel visits when they had their reasons, like the social worker wasn't available, the child was on vacation with the foster parents in Florida. Mother was held.
That's part of the finding of not making reasonable efforts, though.
Yes, but it affects, I didn't argue directly reasonable.
No, I
efforts.
understand. I understand how it affects it.
How's mother doing today?
I do not know, Your Honor.
Have you not been in touch with her?
I have not been in touch personally with the mother in some months.
Huh. When was the last time you spoke voice-to-voice with her?
I did not look that up exactly, but it was probably around May. If I could just, I do think this is significant. I'd just point to my brief at page 43, the footnote 8. There was evidence. I mean, mother testified. This whole child is premature and mother is responsible because she's smoking marijuana idea. I just point to that footnote that there was some, it wasn't testimony, but there's some evidence by a social worker at the intensive care unit that says mother has a seizure disorder and diabetes, and her blood pressure was elevated. We're unsure why the baby was born early, but it was not drug-induced. So that's where I point to a number of factors here where you've got marijuana use, oh no, even though no clear evidence of harm to the child. You've got child is premature, mother's responsible. Again, these things apply mostly in the sense that it was enough to find clear and convincing evidence of unfitness. They apply to the other child.
All right, your time has well expired, but if there are further questions, I want to allow them.
Thank you.
Thank you very much for your argument. Very well argued. I gather the other side will be dividing its time 7.5 minutes and 7.5 minutes. And I'm told, although you'll correct me if I'm wrong, that Attorney Braithwaite will argue first.
That's correct.
Members of the panel, may it please the court. I'm Kristen Braithwaite, Assistant General Counsel for the Department of the Children and Families, and I'm here today asking you to affirm the lower court's decision to find mother unfit by clear and convincing evidence.
So, you agree that at the time of the judge's findings, opiates and drug use was no longer a problem?
Opiates, cocaine were found not to be a problem. There was ongoing concern about mother's use of marijuana and doing so in violation of her safety plan, and explicitly the court found that the way she was utilizing it could still put the child in jeopardy. But I do absolutely...
What does that mean?
Well, contrary to my brother's assertion, while there was testimony that the smell emanated from the car, the social worker did testify that the department had ongoing concerns that mother was using marijuana in the presence of the child.
I understand, but I'm trying to figure out how that related to her care for the child. Oh, in the presence of the child?
There was concern that she was smoking in the presence of the child. That testimony was made by the social worker. There was two different lines of questioning. One was with regards to where the odor emanated from, and the social worker testified that it was believed that that odor came from the car. And while there may be concerns there, putting that aside, the same social worker testified in the same line of questioning, that the department had ongoing concerns that in violation of her safety plan, mother was continuing to use marijuana in
Does that mean, are the concerns based on evidence or just based on the state of mind of the social workers?
The record does not get into the underpinnings of her concerns. The question was really whether or not there was that concern. I will say, mother's repeated unwillingness to abide by recommendations, I think, would provide evidence for that conclusion. At the time of trial, mother testified that she had taken some classes and she understood that marijuana, I believe her words were, it has a big impact on babies in utero, but she also testified that she was pregnant and actively smoking marijuana. And without getting into, I have no ability to judge the appropriateness of that, mother had been provided guidance, medical guidance, that she was not to be smoking marijuana while she was pregnant. Mother testified that she had gained insight into why she should not do that. She further testified she was doing it at that time. So I think a finding that there was concern that she wasn't using it properly was borne out by evidence.
While smoking, that evidence about smoking while she's pregnant, that's even yet another child, right? Not the first two we've talked about, but even a younger child.
That's correct. That was during pregnancy at trial, so a child who's not otherwise in this record at all.
Do you know if DCF has taken the steps about reunification that the judge ordered?
What I know is that the FSS team that was ordered has been put into place. I know there was a permanency planning conference convened, but I do not know whether there was any change in goal. But yes, I know that the steps ordered by the judge were taken by the clinical team.
When was the new permanency plan?
Did you say what was it? Or
When was it?
I don't know that.
But subsequent to the judgment, there's been a new permanency plan.
No, the judge ordered that a permanency planning meeting be convened.
You don't know what the current goal is for this child?
No, I just reached out looking for updated information, and I have not received it.
Okay. Do you know if DCF is in touch with mother?
DCF is in touch with mother.
Okay.
So we can't point to anything, as I understand it, that shows that her marijuana use had a direct negative impact on subject child.
We can point to the fact that when she, and I recognize this is an older detail, but that when she had custody of her child, she chose to purchase marijuana off the streets. It was laced with cocaine, and it resulted in...
That was one isolated instance, as best we know.
It was, but if mother does not follow her marijuana safety plan, then it stands to reason that other risk persists, and the court did find risk persisted.
Did she consistently visit?
She did not consistently visit. Her visitation varied over the course of the...
Pretty good?
What's that?
Was it pretty good?
No. By the time trial took place, the court found that mother had missed approximately 75% of her visits.
How often did DCF cancel these visits?
DCF canceled at least 4 visits, and I do know that that was tied to the court's finding that reasonable efforts weren't made. The department did not do right by mother in that it did not then make up for all of those visits. The court does identify that in its findings. It doesn't blame mother for all of the visits, but mother was canceling visits left and right.
Do you know when and how far apart the visits that DCF canceled were?
I know that visits were canceled when the foster parents took the child on vacation, and I believe that happened in 2 consecutive Christmas seasons. I also believe there was an instance of a social worker being sick. This isn't a canceled visit, but within that time frame around when one was canceled for a social worker being sick, my understanding is that one of the children was brought 40 minutes late to a visit, and that time was not then extended on the back end.
How long was the visit?
I believe the visit was
2 hours?
I believe it was just 1 hour.
1
An
hour.
hour or 2 hours?
I can't answer with confidence. My
I
apologies.
mean, we have the record,
I
obviously.
apologize, but it was a 40-minute delay that wasn't made up. And I will say, the department is not here asking that this panel find that it did make reasonable efforts. But there is, and I can speak certainly to the mother's unfitness, but to speak to the reasonable efforts piece briefly,
I mean, there's no need, it's not on appeal, right?
I don't believe that it is. It's just been a topic of conversation.
Mom have stable housing?
Does mother currently have stable housing?
Throughout the course of this case, did she have stable housing?
Throughout the course of this case, mother's housing varied a lot. It was always affiliated with domestic violence shelters, and yet her abuser would frequently live with her.
Did she have stable housing?
I think that the answer is no, but she did have housing. She regularly had housing. The stability of it was in question.
Why do you say it was unstable?
What's that?
Why do you say it was unstable?
Why do I say that?
Yes.
There was an incident where mother had a guest that banged down the door of a neighbor. There were complaints made. Mother was upsetting neighbors. She was playing her music so loud, 51A reports were being filed, concerns of babies screaming. And there were also a number of moves.
How does that impact the stability of her housing, that she was playing music loud?
Well, interestingly, the music loud was the one piece that mother indicated was impacting the child because she indicated it was loud enough to be damaging to the child's ears. But the more unstable piece would be the concern for people coming in and out of the housing. And that concern was alleged, which simply sets the stage as far as the record goes. But then in the subsequent investigation, there were beer bottles, Hennessy, I believe marijuana wrappers. There was evidence of...
That was the night that she smoked a marijuana laced with cocaine.
That's correct. That's correct. Yes.
Your time has expired, though if there are further questions. No, I see none. Thank you very much for an excellent argument.
Thank you very much, Your Honors.
We will hear next from Attorney Joya, whose name I may have mispronounced.
Good morning, and may it please the court. Ana Maria Joya on behalf of the child. I'd like to briefly discuss 4 points with the panel members.
Could you move
One,
the
I-
mic a little
Yeah,
closer
could you
to
move the mic? Yeah, great, thank you.
I'd like to briefly discuss 4 points with the members of the panel. I'd like to start with mother's record of missed visits, which account to 75%. This little girl went into foster care on March 7th, 2021. The last day of trial was January 17th, 2023. That time span, 1 year, 10 months, and 10 days. During this time, mother canceled 15 visits. 15. There were some visits where she just refused to show up. And although her visits during April of 2022 improved to unsupervised and overnight visits, that progress was sadly shortly lived. This is in
Did mom have significant mental health issues?
I'm sorry?
Did mother have significant mental health issues?
Mother had significant medical issues in general. She had mental health issues, she had epilepsy, she had PTSD. There were a number of medical issues that mother was suffering from during this time. Yes.
But mental health wasn't a primary one.
I wouldn't say that it was a primary issue, it was just one of many.
Okay.
These 15 canceled visits by mom, this is an astonishing number of visits to miss. This is a missed opportunity for mother to bond with this little girl. And consistently visiting a child is a factor that a judge can consider when determining whether a parent is fitness, particularly if a parent refuses to visit with a child. Mother's inability to consistently visit with this child was one of many factors that the lower court properly considered when he found mother unfit. Regarding mother's maternal history, at the time of trial, all of mother's previous children had either been adopted or were currently in foster care. She wasn't parenting any of them at the time of this trial. Before this little girl was removed, mother could not comply with a simple, routine follow-up appointment that had to be rescheduled 7 different times. And once this little girl went into foster care, up until the day of trial, again, 1 year, 10 months, 10 days, mother could not comply with her action plan, she could not follow through with her own medical doctor's appointments, and she could not maintain a consistent visiting schedule with this little girl. And just to briefly touch upon mother's own medical needs and her neglect, we've heard that mother suffers from epilepsy. On the night this little girl was removed, on March 7th, 2021, mother called her friend and purchased street marijuana that eventually caused her to be hospitalized. Similarly to the case petition of the Department of Social Services that's cited in my brief, where a judge found a mother unfit because, and I quote, "although prone to seizures, mother failed to seek medical attention to control her condition, which, if uncontrolled, is dangerous to the child," end quote. The judge here properly considered this to be one of mother's many issues in her inability to properly seek medical attention to treat her seizures. So mother's own medical neglect then bleeds into how she treats her children and causes medical neglect to her children. In addition to mother's inability to properly take care of herself, it is further exhibited in her sporadic record of missed medical appointments for all of her medical diagnoses. And although by the fourth day of trial, mother had made efforts through her own providers to adjust her medication in order to be able to properly take care of this little girl, I suggest to the court that the lower court found mother's efforts, although admirable, to be simply too little, too late at the time of trial. The last point I'd like to briefly address is affirming reasonable efforts. And under care and protection of WALT, the 5 remedial measures are within the judge's authority to direct DCF to continue to reunify. And unless the court has found that DCF is excused from making reasonable efforts to reunify because of one of the statutory exceptions listed in Mass General Laws, Chapter 119, Section 29C.
Is DCF's goal still reunification?
I believe that DCF's goal is adoption, Your Honor. And the permanency plan, a trial for that has been set for 2024.
Is there an adoptive resource?
Yes,
Is it the foster parents?
yes,
And the child is still with those foster parents?
Yes, she
now?
is.
And you've met with her?
yes. I've seen her as recently as September 24th, yes.
Okay.
So lastly, I will just say that the judge in this case did not find that any exception applied to DCF, and therefore DCF's obligations remain up until the trial where a mother's rights are to be terminated.
Do you know if the reasonable efforts portion of the judgment is being implemented?
Based on my conversations with trial counsel, I know that there was some efforts done to provide mother with an action plan, an updated action plan.
And do you know if there's visitation between the child and mother now?
Last time I spoke with trial counsel, there had been some attempt to try to do visitations. I don't know how successful those have been.
But it's still, DCF is still, whatever, ordering it or?
Correct.
Okay.
And unless there are any other questions from the panel, we ask that the judgment be affirmed.
All right, very
Thank you.
good. I see none. Thank you very much. Also an excellent argument. The case is submitted. The next matter we will hear is number 23-178, Connor versus Marriott International, Inc. And we will hear first from Attorney Savitska.
Good morning, may it please the court. My name is Alina Savitska. I'm here on behalf of the plaintiff's appellants. The lower court in this case erred in granting summary judgment in defendant's favor on plaintiff's 93A claim. At the very minimum, summary judgment was not appropriate in this case because there were a number of facts in dispute between the parties. But more importantly, the court made a mistake as a matter of law by failing to recognize that the Fairfield Inn clearly violated the Massachusetts innkeeper statute, which creates a clear predicate for liability under 93A, as it is a statute that's enacted for the benefit of the
Did the
public.
Fairfield Inn have anything to gain by denying the stay?
I am not aware, but intent is not something that is examined. Intent is not required under Chapter 93A.
I know, but my question is, did they have anything to gain by denying the stay? They're in the business of renting out rooms, right? Okay, so did they have anything to gain by denying them in the record?
There's nothing in the record to this effect, no.
So the innkeeper statutes, it's a bit confusing, but your contention is that your clients were asked to leave because they violated an unposted policy, but they never got around to violating the policy, right? Because they never started selling. I mean, right?
Sure, yes, Your Honor. On the night in question, one of the many points at play here is that the plaintiffs, one of them had just arrived and checked in, the other one was arriving at the hotel. They were not meeting with any prospective clients.
So they didn't get asked. They were told there's a policy,
Yes.
and which they hadn't yet broken because they hadn't. I mean, at that point, they could have stayed and said, okay, we won't see any clients, but they didn't. What happened was there started to be a fight, though, right?
I wouldn't characterize it as a fight, Your Honor. Plaintiff Connor asked to see a copy of the alleged policy. She was not provided with a copy. She said she wouldn't leave, and at that point, the hotel chose to call the police.
Can I ask about your interpretation of this statute, this innkeeper statute? As I'm sure you're aware, has not been construed much by our courts.
That's correct.
What leads you to conclude, and how would we figure out whether this list of reasons is comprehensive? It just says they may remove people, and then it lists a bunch of things. It doesn't say they may not remove them for any other reason. But your argument, at least about the statute, requires that that be the comprehensive list.
Sure. Your Honor, I think one part of it comes from the plain wording of the statute. There's 4 clearly set out grounds that, are not really open to interpretation. And aside from those 4 grounds, any other removal must be based on a policy that's in writing and that is posted.
What makes you say that? I mean, I agree that they can kick someone out if they violate a written policy. But let's say they've never thought of a policy like, you can't bring a tiger in here. Okay, so they didn't post no tigers because it never dawned on them that someone would bring one. And the person is not going to cause a disturbance. Well, I'm a trained tiger trainer, and I always put his muzzle on. So, but we've got the big tiger show downtown, so I brought my pet tiger. And the hotel's like, look, I'm sorry, you can't have a pet tiger here. You're saying they can't, if they haven't written no tigers, they can't remove that guest.
I think, Your Honor, well, tigers aside, and I think having a tiger might threaten to cause a disturbance, but I think that hotel...
I'm not sure what that means exactly, threaten to cause a disturbance.
Well,
I guess if someone else heard about the tiger being there, they might be upset.
I mean, I think, Your Honor, here we're talking about a very common situation where hotel guests are coming by to meet with prospective customers. This happens a lot. This happens in the consumer context. Stores host these types of, showrooms at hotels.
Well, this is a different question. I'm asking about the statute, the innkeeper statute. I mean, and I'm not sure why you emphasize that. There's a lot of stuff here that seems to me like it could be 93A stuff without the statute. I think it's a disputed question of fact. Did they know this is the reason they were coming here? Did they know this was material to their decision to rent the room and frankly come from New York and so on? And did they either have a new rule or have a rule that it wasn't permitted that they didn't tell them about till they got there? I mean, I could see how that could be unfair, sort of a fraudulent omission of something important. But I'm not sure I understand, you're asking us to construe this never construed statute, and I'm just having a hard time, without, I just thought of the tiger example, but I'm sure we can come up with some other examples of something someone hasn't thought of, but really is no good. For example, I don't know if this would come within the statute, something that smells very bad. But it's the Limburger cheese convention. Yeah, but we can't have Limburger cheese in the room, at least not in this huge quantity you've brought. Everyone up and down the hall is complaining about it.
Your Honor, again, first, I do think that the language of this statute does require any policy outside of the foregrounds to be in writing and posted.
No Limburger cheese.
But,
No, really, I'm not making that. I'm thinking of things people might do in their hotel room that might bother other guests, but not cause a disturbance.
I think let's kind of try to pair this statute with the facts of this case. Under the facts of this case.
No, I have to, if the statute is not exclusive, if that's not an exclusive list of reasons, then it wasn't violated. It may not be permissible, it may be a 93A violation to make this a reason for kicking someone out. But it wouldn't violate the statute if that list isn't comprehensive. So don't we need to figure out if the list is comprehensive?
I mean, in my reading of the statute, and I think the language is fairly clear that there must be a policy and that it must be.
It doesn't say they may be removed only if. It just says they may be removed if. Maybe it just creates a safe harbor.
Well,
Look, hotel, if you posted no Limburger cheese prominently and the Limburger convention is happening, you can turn those people away or kick them out once they unwrap their Limburger cheese.
Sure, but again, I think the wording, the legislature could have worded the statute differently. It could have said, or for other reasons in the discretion of the hotel. It could have said the hotel has the ability to remove guests. That's not how it's worded. There's 4 categories plus the written policy. I would also like to point out that just kind of the general purpose of this statute, it appears alongside other provisions that provide safeguards to guests. So it is a statute that's meant to protect the public, i.e. the guests.
Didn't the hotel seem to suggest that by not having commercial sales in showrooms in the residential rooms was providing a safer environment for the guests, because you didn't have people who weren't known to the hotel just kind of walking in and off the street and walking throughout the hotel?
Your Honor, I mean, that may be a legitimate concern. It is not held up by the facts of this case. Again, as we mentioned before, on the night in question, the plaintiffs were not meeting with anyone. They had just checked in. Secondly, they had done this for many years prior. The hotel knew they were coming to do this again.
Do you know when that was? I know you said that they had done this for many years, and that seems to be an issue in dispute. So is there any record support other than them saying that they had done it for many years? I'm just curious whether.
I actually don't believe it's a disputed fact.
I'm asking, is there any record support that they had done it? Was there any receipts or any evidence that they had been there before?
I'm not sure anything has been produced. We have the plaintiff's testimony and their affidavits to this effect.
And so the hotel said they had been here the summer before, but beyond that, wasn't that an issue in dispute or no?
I don't believe there's a dispute that they'd come for several years. I don't think the hotel.
But if there is, summary judgment should have been denied anyway, right?
That's correct, yes, Your Honor. And I think there are a lot of facts between the parties that are in dispute, but what is not in dispute is that there was no policy in writing. We don't know when such a policy was enacted, if at all. At the very most, it was enacted on the spot, but again, there has been no clear testimony, no clear evidence about this policy. As far as we know, it doesn't exist.
So the question that something is an unfair or deceptive trade practice, is that a question of law?
Yes, although I think that it is, it's dependent on the facts of the case, but there are legal parameters.
Because this is, let me follow up. So suppose we were to reverse summary judgment, and this is go to trial. What would you tell the jury? What would the jury have to find for your client to win?
Sure. So our theory here, and which is supported by the Claremont case, is that where there's a clear violation of a statute that's for the benefit of the public and other circumstances indicate unfair or deceptive conduct, that amounts to a 93A violation.
So the jury would have to find that there was a violation of the innkeeper statute, and that the innkeeper statute was, what is it?
For the welfare or the benefit of the public, and that the other circumstances indicate unfair or deceptive conduct, which are two separate kind of buckets of conduct. And
Is there any way we could instruct the jury without reference to the innkeeper statute?
sure. I think the conduct in this case was unfair because of the duties that hotels owe to guests, which are codified in the case law. They're codified by other statutory provisions. Again, plaintiffs had visited on multiple occasions. They were open about what they were doing. Defendants never raised an issue. For this stay, plaintiffs requested specific suites to meet with customers. They sent merchandise ahead. The hotel never raised an issue. It allowed them to show up and then told them, look, you can't conduct business here.
If your clients had never come to this hotel before, and this was the first time, would the case be different?
Perhaps, although again, in this specific visit, they were clear about why they were coming. They had sent merchandise.
That's a disputed fact. But I'm not saying it isn't disputed. It's a disputed fact. The jury would have to find, yeah, I think they knew why they were coming there and what they intended to do. And then even without the statute, you might have a claim.
Sure. And that's unfair conduct. And also, again, deceptive conduct is a separate issue where the hotel failed. There's no question. The hotel failed to inform the plaintiffs of any policy that prohibited business activity up until they showed up. And that failure to inform is deceptive because had they known, they would have gone to a different hotel. This was the purpose of their visit. So there's two separate bases of liability, even without the statute.
Let's assume for the sake of discussion that they did have a policy that says you can't conduct commercial business out of your residential room. And they came last year and the manager said, hey, that's okay, we're going to let you do it. So does that mean they have a right to do it from now on?
I don't think so. I think they had asked on this night to see a written policy, and there was no policy. Had they seen it, it might have been different. They might have said...
A policy that permits it?
I mean, I don't think a policy needs to specifically permit the conduct in question.
Commercial business out of a residential hotel room?
And again, I think it is something that is pretty commonplace. I don't think it's specifically prohibited.
I remember doing interviews when I was a law student for whether I'd be hired or not by law firms in hotel rooms.
Correct, so did I, yes. Yeah, so it's a pretty commonplace practice. Again, at the very, very minimum, in this case, there were enough facts in dispute that made summary judgment on this issue improper. And again, I want to reiterate that if a violation of this innkeeper statute is found, that is a clear path to liability under Chapter 93A. And
One quick question. There's evidence that they were setting up, that I guess the first one who arrived was setting up the racks in the outward-facing windows of the hotel room? Is that?
I think that may have been the case in a previous visit, and yeah.
But they hadn't got around to it in this particular visit.
I don't think so. I think she did check in. She did start unpacking.
Do we know what floor?
On the street level.
What floor?
I'm sorry.
Do we know what floor she was going to be staying on?
That I don't know, and I'm sorry.
Was it the ground floor?
Not sure.
Okay, sorry.
Same question.
Yeah, I am not sure.
All right, I see that your time has expired, and seeing no further questions, thank you very much for an excellent argument. And we will hear next from Attorney Morris.
Judge Rubin, I'm sure you did not create a disturbance when you were interviewing for those law firms.
Not for the other guests, no.
Good morning, may it please the court. My name is Sally Morris. I represent Geary Dedham LLC and Marriott International, doing business as the Fairfield Inn in Dedham, Massachusetts. I'm here to ask that the court affirm the Superior Court's granting of summary judgment in this matter. We think the order was correct, that there's no dispute of the material facts at issue in this case, and that the case was properly decided as a matter of law. At the heart of this case is the intersection of the service demands of an individual guest versus the obligations of a hotel to the comfort, hospitality, good service, health, and safety of all the guests staying at the hotel.
Do you agree? Oh, I'm sorry, go ahead.
Did any guests complain?
There's no information in the record that any guests complained.
So, assuming that the facts as laid out by the plaintiffs, that they'd been here before, that they've sold their property before, that this is not something new, that's why they chose the Fairfield Inn, how, as a matter of fundamental fairness, can this just be fair? I mean, they send all their stuff in advance. They've been planning on coming, they've been talking to the manager, then they show up, and all of a sudden, no, you can't stay. I mean, how's that fair?
Well, I think that there's two different pieces of that. One is that the hotel didn't say, no, you can't stay, and that's not a disputed fact in the record. Ms. Connor testified that they asked her,
You just can't sell your stuff
you
out the
can't sell
window.
your stuff out of your room. You're welcome to stay, but you can't sell your stuff out of your room.
Is it your position that they used to allow this at the Fairfield Inn?
I can't sort of point specifically to where this would be in the record, if it's in deposition testimony.
Well, it's in the plaintiff's testimony. Do you dispute the fact that, that this kind of activity might have at one point been permitted at the Fairfield Inn?
Well, for the purposes of the summary judgment record, of course, we have to accept the plaintiff's testimony
We agree with
as
that.
true. So taking that plaintiff's testimony as true, my position would be, as a matter of law, that's not sufficient information to put a hotel who could change ownership, turn over employees,
Her
et cetera.
testimony is that some manager or deputy manager told her her name was on a do not rent list.
She did testify to the...
Okay, so you rent a room to someone who's on a do not rent list. They show up and you say you're on a do, now you're saying we said she could stay, so I guess she's not on a do not rent list, at least according to you. So I don't know, so maybe people are lying to her at the hotel to get her to leave. That sounds a little 93A to me, but.
There's certainly no evidence of that.
I don't, there is evidence of that. The
There's no
evidence
evidence
is
that anybody lied to
her
her.
testimony is that they told her she was on a do not rent list.
She did testify.
Okay, so let's assume that's true. It's,
Seen the list and they couldn't produce it, right? So, then
I think that she testified to that.
but then they
as well.
tried to kick her out anyway.
They asked her not
Why
to-
isn't that, they told her she couldn't do what she had come there to do. Why isn't that, well, let's take all the facts in her testimony. The hotel knows what she intends to do when they rent her the room. And she's done it before there. And they, whether they have a policy or not, but let's start with, and they now have a policy. You don't think the hotel has an obligation to tell someone before they get in their car and drive from New York to do a thing?
Absolutely not. Absolutely not. And it's because...
And that's because hotels can't fraudulently fail to represent something, because if another business did it, it would clearly be a fraudulent omission.
Well, so first of all, I don't think there are any facts in the record here that indicate that the hotel had any duty to make any disclosure. And I'll give you an analogy. Let's assume that the hotel has a pool or a breakfast bar. And let's assume that somebody booked wanting to come swim to the pool. And they even said, oh, my kids packed their bathing suits.
Mm-hmm.
And then they show up at the hotel and the pool is out of order for some reason. That's not a consumer protection violation.
If it's out of order for some reason that is new and nobody knew, but if I'm an Olympic swimmer and I've chosen your hotel because of the Olympic-sized pool, because I'm going to keep practicing while I'm there, and you shut the pool and turn it into a ballroom, and you don't and I've told you that's why I'm coming, and you don't let me know, and I fly across the country and I'm like, I can't practice here, That's not a sudden, the pool is broken situation. That's a, we closed the pool and didn't let you know situation.
But even if we closed the pool and didn't let you know situation, fraud means we intentionally closed the pool because we wanted to get you.
No,
and we didn't
no,
let
no,
you
no.
know.
Fraud means omitting a material fact from your representation.
Where
and
there's a
once you
duty-
know that it's material
Once
to
where
this,
there's a duty to disclose.
yes, a duty to disclose that the material reason that they're coming to your hotel is no longer available. I mean, I don't really understand how you think hotels operate.
Well,
But it seems odd to me that I could choose a particular hotel because of a particular feature. I understand if there's an emergency, it's broken, we're working on it, we're trying to fix it, we didn't know. But we got rid of that feature, we didn't let you know. It would be more convenient for you if you didn't have to, but I don't know why the consumer, someone could fly from anywhere. I came here from Paris, and I came to your hotel only because it's the only one that has kosher food.
Right. And
Oh, we don't serve kosher food anymore. Well, I told you that's why I was coming there. What?
I didn't mean to interrupt, I'm sorry.
No, please.
Well, I'm saying, what I was going to say is, these are the normal transactions that, in the reality of a hotel business, that occur every day. They
You
occur in
routinely fail to tell customers when a material reason they're coming there has been changed through your own volitional act.
Well, I would disagree with your
Just
characterization.
said that that's what happens every day.
I would disagree with that. I would say that there are things that may be material to particular guests that may or may not be communicated, but in any event, how is the hotel to receive that information, to know that it's material in the sense of a duty to disclose? There's no fiduciary relationship, there's no...
I guess if they tell you...
change all the time.
I guess if they tell you, the reason I am coming to your hotel is the Olympic-sized swimming pool so my training regime can go on. The reason I'm coming to your hotel is because you have kosher food. The reason I'm coming to your hotel is it's one of the few hotels that allows me, without exchanging cash, to have customers come and look at samples in the hotel room. And they tell you that, and you say, yes, great, come, that is what we do.
I would argue that the law does not establish a duty to disclose in those circumstances.
Can I ask about your argument on the, under the innkeeper statute? You say the action was justified not as because of a policy, but because of either creating a disturbance or threatening to create a disturbance. What exactly was the disturbance or that happened?
Well, we would say it's twofold. One is the failure to comply with a reasonable directive from a hotel staff member.
How did Ms. Fishman do that? She was in a car.
Ms. Fishman, when she arrived, well, there are further facts that are not disputed, and that for over 2 hours, Ms. Connor and Ms. Fishman argued with the police.
With the police?
With the police.
Okay.
To get the police to convince the hotel
But Ms. Fishman didn't cause a disturbance in the hotel, did she?
to allow them to stay for their entire time and continue to engage in commercial activity, even though the hotel had said, we can't have this going on. That either causes a disturbance or threatens to cause a disturbance, which is the language of the statute. And then in addition to that...
So customer complaints is a reason you can kick people out. It's a disturbance to us.
Well, that's what the statute says. The statute...
It says a disturbance, but that's a legal question. What's a disturbance, right?
Right, and the plain language of the statute, as we talk about in our briefs, says that it's the potential to bother others, which is what it says cause or may threaten to cause.
Hotel staff? You're bothering the hotel staff. You ask them to replace the towels. We only replace towels every other day. Stop asking them.
There are circumstances, I mean, maybe that's a hotel that's going to go out of business, but that's different than...
Well, maybe because of the liability imposed by statutes.
Well, but that's a different question. As to whether a business is conducting itself with good customer service, that's a different question than whether it's liable.
I've interrupted, actually, your answer to Judge Massing, so maybe you want to
The
finish.
one was fighting the directive. What's the other one?
Arguing with the hotel staff, and then refusing to leave when the argument continued, and refusing to leave while the police were there. All of those things would cause a disturbance.
So you're not saying that selling or showing high-end kids' clothing causes a disturbance?
Well, I mean, I think that the hotel had concerns, as the deposition testimony indicates, that there was a risk potentially to the safety of other people in the hotel by having that many people come and go. And it's different than the law school interview, because they're hanging stuff all in the windows, and people are coming and going all day long. That's
So if they didn't
different.
hang it in the windows, then they could have stayed. So if you'd drawn the drapes, that would have been okay, because I don't remember anyone telling them that.
The volume of the number of people that would be
How
coming
many
and
people were
going.
going to come and go?
They said that they were booked solid for all 3 days.
Okay, how many is that?
I don't know.
Okay, so
I don't know that the number is in the record.
Okay, well, I don't know how many interviews they do when a law firm comes to a campus and rents a hotel room, and my guess is it depends on the hotel. I'm sure some hotels don't allow it.
And that would be within their business judgment.
Well,
And that-
or they might have to have a policy. You've never produced a policy.
There's
Do you know at the
nothing-
Fairfield Inn, can people do interviews for jobs in a hotel room?
I don't know. I don't know.
Well, doesn't that actually matter?
There's nothing in that statute that requires the hotel to have written policies. It's not like you have to hand out an employee handbook to every guest who's going to come stay at the hotel.
I understand. If you put yourself in the position of these ladies, okay, wouldn't you be frustrated when you got there?
Sure,
All right. and so
frustrated.
Wouldn't you be able to voice that frustration? You're saying, but if we voice the frustration, we don't just say, okay, and leave, well, now we're causing a disturbance and we can be removed.
Well, it escalated and escalated and escalated, and it was clear that they never had any intention to follow the directives of the
They
hotel
felt they were
staff.
being wronged.
Right, and there are ways to express that.
And they were.
Insisting on being arrested by the police is not a peaceable way to express that.
Insisting on being arrested by the
But Ms.
police.
Connor
No, she
testified
was
to.
willing to stay in the hotel and
She
have
said-
her appointments.
She testified to the fact that I won't leave unless you arrest me.
Okay, so she didn't ask to be arrested, she asked not to have to leave.
Right, and she
Okay.
said, the only way I'm going to leave is if you arrest me.
Did she say that? Or did she say, they said, we'll have to arrest you, and she said, do what you got to do?
I'll have to check the deposition testimony, but I think she said, I'm told them I wasn't going to leave unless they arrested me.
So can I, they're not quite sure how many guests are going to show. They say they're booked. I mean, but you don't know who's going to come, how many, and and I don't know if children's clothing retailers are known to be a crowd that, causes a lot of ruckus. But, I mean, the plaintiff raises a concern that you could just sort of make up a policy and, as a pretext for people you just didn't want to stay in the hotel. Isn't that a concern here?
Well, there are other laws that would prohibit the hotel from creating pretextual reasons to exclude people who are protected, and of course they can't.
Isn't everyone protected? It's a hotel.
Everyone who makes a reservation at the hotel has reserved a right to come and stay and follow the hotel's rules and directives of its
Okay,
staff.
but we're talking about pretext now. I know this doesn't happen at most Marriotts, but sometimes people are jerks. And you show up and you're doing something, and someone who's the assistant deputy night manager decides to tell you you can't. There's no policy. And then when you say, I don't know anything about that policy, they go and get the assistant night manager. Well, they work with the assistant night manager all the time, and so she backs them up. No, you can't do that here. And you say there's no policy, and they get the manager. And the manager comes, and he has to work with both of these people, and even though he knows there's no policy, he backs them up. I'm sorry, there's a policy, but there isn't. Is that okay?
So the answer directly answer to your question is yes. And the reason is because the question before this court is whether the Superior Court properly exercised its gatekeeping function in determining what rises to the level of a consumer protection unfair and
You don't
deceptive
think it would
act of
be a
practice.
deceptive practice to lie to someone about a non-existent
It's the
policy to
word-
kick them out?
The word policy is often used in a colloquial way.
Okay, let's use it as a rule. We have a rule here. You can't sell goods from the hotel room, even if you're not taking money. You can't take orders in your hotel room. Okay, let's say you say that, and there is no policy. It's just someone being a jerk in the middle of the night.
And a business has a right to run itself into the ground if that's what it's going to do.
But it may not have a right to kick people out who
It
have
doesn't
paid for a
mean-
room.
It doesn't, well, the money was refunded here, and that's undisputed in the
Refunding the
record.
money is not the same. If I fly to Europe and show up at my hotel, and they say, I know you've given us $2,000 for your stay here. Here's the money back, and everything in town is sold out. You think that's okay?
A business has a right to run itself into the ground, and that is part of the ability for a business to exercise whatever judgment it's going to exercise,
And so
which
they would have
is,
been okay saying that they have a 11 o'clock curfew?
that they have 11 o'clock?
Yes,
Yeah,
they show up and they
absolutely.
say, oh, now, all of a sudden, we now have an 11 o'clock curfew, so you got to be in by 11 o'clock.
Absolutely,
That's permissible.
yeah. I think some do.
Some put in place a rule like that and tell people that that's the rule, having never told them before, and they've stayed there 1,000 times, and there's never been a curfew before.
Businesses are free to change their rules.
Well, businesses aren't free to violate statutes, though. Your time has expired, but if there are further questions, I see none. Thank you very much. Interesting case, and well argued by both of you. Thank you. We're going to take our traditional mid-morning break, and we will return to hear 3 more cases in about 10 to 15 minutes.
Your session, please be seated.
Welcome back, everyone. We will continue our sitting this morning with number 23-167, Moynihan versus Contributory Retirement Appeal Board. And we will hear first from Attorney Scannell.
Members of the panel, may it please the court, my name is Tom Scannell, and I represent the appellant Ellen Moynihan. Ms. Moynihan is a career public school teacher. She started with 4 years in Norfolk, Virginia public schools. She spent 3 years in the Stamford, Connecticut public schools, then 6 years in Sutton before Sutton was a member of the Mass Teachers Retirement System. She came to Worcester in 2001 as a teacher, and she retired in 2019 after 2 years as a principal. She's seeking to have the 4 years that she spent in Norfolk to start her career recognized as credited years for purposes of her retirement.
So one of the things that the Contributory Retirement Appeals Board relies on is that the Norfolk retirement scheme paid in to her plan, I'm going to call it a plan, solely. None of her own monies were contributed to funding that allowance plan, as distinguished from Sutton and Connecticut. And they seem to say that that's kind of a central reason, and because of that, somehow there's a risk that she'll be able to double dip, I suppose. And I'm trying to figure out what exactly that means. So
Well,
maybe you can help me.
Yeah, a couple of points there, Your Honor. First, the Virginia statute essentially required member contributions. It was the individual
You want to call
districts.
them member contributions, and I know the letter says they're essentially member contributions, but at the end of the day, she didn't pay any monies out, she didn't write any checks, the employer paid them, and she wouldn't have been entitled to that money by way of salary.
There's a key factual difference, Your Honor, and it would have been good to develop this at hearing before the division, before DALA, but a key factual distinction is that Mrs. Moynihan actually did pay. She paid Social Security. It was required. Essentially, this was a hybrid plan. She had to...
Okay, but the regulation makes it, if any employer contribution goes in, makes it an ineligible year.
Right.
Now, let me ask you this. Let's say she had left the money in there. And now that she's retiring here, having not vested there, presumably she would, I mean, again, I don't know the details of the Norfolk, Virginia plan, but the way at least some pensions I'm familiar with work is if you don't vest, you get back your contributions plus the interest it's earned. I get a statement from the Massachusetts Retirement Board explaining how it's earned 0.1% every year since I've been a judge, leading to a series of questions such as, who's in charge of this? But in any event, you get it back with some interest. Might that be a retirement allowance?
I don't think so, Your Honor, because, number one, it was considered by everybody as a refund, number one. Number two, it came long before Mrs. Moynihan retired, and it was required. Virginia actually suggested that she take it because she had invested.
I'm not interested in what they suggested. I'm not interested in how you characterize it. She took the money out. It could have been their suggestion. They didn't force her, but whatever. I'm just trying to figure out if there's any difference between receiving it when you retire and receiving it when you separate from service, since the statute says retirement allowance.
I think there is significance, Your Honor, based upon the MTRS's own regulation. And I say that because the MTRS regulation, as worded, requires that there be a planned benefit. It says if there's a defined benefit plan or if there's a defined contribution plan, but it says where those plans are based upon employer contributions. That's different. That's very different. That a planned benefit is a retirement benefit. It's a retirement allowance. That's what
Well,
they're
I mean,
trying
I
to
understand. I'm not sure how to characterize it. For example, and again, the plan I'm most familiar with, although I'm sure inadequately, is the judicial retirement plan we have here. And my sense is that if you resign the bench before some combination of, I don't remember if it's 10 or 15 years and some age, 55 or 60, I don't remember, you haven't vested at all, and you get back the money you put in plus interest. So that's not a defined benefit, right? A defined benefit would be X percent of your, regardless of what you put in, X percent of your salary, times some factor, whatever it is.
Exactly.
And then you get that every year.
Right.
That's the defined benefit. And a defined benefit plan, which is also what the regulation says, a defined benefit plan requires the payment to you of a certain defined benefit, regardless of whether you could have put in $8. If you're entitled, and you get it.
Right. No, I think, Your Honor, I think what we're talking about, though, is a planned benefit. It's a retirement benefit. Or to use the words of the statute that's operative, 32, Section 3.4, a retirement allowance. We're not talking about a payment made or a refund made prior to retirement. The statute's very clear that the disqualification requires that there be a retirement allowance from the other state. And then, and I'd suggest maybe not very well, but in then trying to define retirement allowance, the system promulgated this regulation, and they said it's a planned benefit. It may be based on employer contributions, but you still need a planned benefit. It's the only way it makes sense, because otherwise they're changing the statute. They're adding additional payments that could disqualify that aren't in the statute. The statute says nothing about a lump sum reimbursement. It says nothing about a refund, and neither does the regulation.
So let me ask you a hypothetical. I mean, I understand that's what the language of the statute is a problem. I mean, it also says shall, which seems to be a future thing, but that can't be right, because, and so let me give you my hypothetical. Suppose Virginia had a system where after you get tenure, which is tenure is 3 years, after you get tenure, you're vested in the retirement plan. And so after 4 years, your client's got a retirement benefit. When she retires 30 years from now, she can get like 10 cents a month for the rest of her life. And Virginia says, but I'll tell you what, instead of that, we'll give you a lump sum payment now. We'll give you the present value of that, and you get $4,000. Wouldn't that be a retirement benefit?
I think it would, Your Honor. Yes, I would agree with you. I think that would disqualify her because she had vested and it was a retirement benefit. Now she would be getting a retirement benefit from 2 different states, the MTRS.
But she got it way back, and she took it. She took it in 1988. They gave her $4,000.
Right, 92. But
yeah, but I mean,
yes.
I mean, in my hypothetical, where it was a payout instead of the retirement benefit.
I think if she had vested, it would still be a
That wouldn't be a retirement plan or an allowance or anything like that.
So wait, so is it the vesting that's the critical factor for you?
I think it is, Your Honor, because otherwise you don't get any retirement allowance from Virginia. In fact, the paperwork from the Virginia retirement system points out that taking a refund, this is on the record appendix at page 96, it says, taking a refund cancels your membership and eligibility for any future VRS benefits. So it takes her out of the realm of a retirement benefit or a planned benefit.
Why were they encouraging her? I think you say that, or were getting ready to say, that Virginia was encouraging her to take the money out. Did I hear you say that correct?
Yes, Your Honor. They
So
did.
why?
They did encourage her. I don't think it's of record, but I understand that it's because it didn't factor into their investment decisions. It couldn't be used essentially as part of their investing in developing interest in annuity and so forth. They told her basically that you take it out because it's not part of our system.
So I'm not sure I fully understand. Let's say that she didn't take it out. Would she be entitled to it today?
Yes, I think she would. And in fact, there is provision
So, go ahead, let me let you finish.
because I think in Connecticut, now granted, there's a difference between member versus employer contributions, but in Connecticut, I think when Mrs. Moynihan applied, and this is in the record, she hadn't taken the money out, and there was actually a communication that's in the record from Connecticut saying, oh, by the way, you have this money in here, but in order for you to use it to buy back your Connecticut years in Massachusetts, you need to take it out. So I think that would have been the situation if it had stayed in there.
Benefit to her?
Well, no, it's not a retirement allowance, Your Honor. It's not a retirement allowance.
And then the Connecticut thing,
And
that was...
the statute is very limited. In fact, it's interesting, when the MTRS denied her, their letter actually quoted other language which talked about retirement allowance, pension benefits, or other similar payment, which applied to different buyback provisions for different people. I'm not sure whether it was private school people in Massachusetts or not, but they cited the wrong, the inapplicable provision. But the point is, the statute is clear that it's a retirement allowance that disqualifies you. You need to have a retirement allowance.
The Connecticut one that you were talking about, that was all her, that was member contribution.
Yes, it was, Your Honor.
So,
Yeah.
okay.
Yeah, and Sutton
And that's and Crab is saying, well, that's the difference. Like,
Right.
that was a member contribution. This one is an employer contribution.
right, that's what they rely upon, Your Honor, but their own regulation doesn't say that. It says, means a retirement allowance means a benefit, a defined benefit plan or a defined contribution plan in which a member is eligible to receive or has received a benefit based in part upon employer contributions. But it still has to be a planned benefit.
Right.
It can't be a refund.
One of the reasons they rely on, I'll say, is that they want folks who do the out-of-state service to be on the same footing as folks who are teachers in Massachusetts, right?
Yes, Your Honor.
Okay, so help me understand what the difference would be had she the 4 years in Virginia versus had those 4 years been in Massachusetts.
That one confuses me a little, Your Honor. I had to rely upon another explanation of that this morning, but on our reply brief at page 6, we kind of set out the difference between what would have happened if
The
she...
grid with all the monies, the
Yeah,
calculation.
right, the
That was a
calculation.
little confusing to me.
It was, Your Honor. As I went back and read it, I had to get retaught on it. But the fact of the matter is, she wouldn't, if she had worked those years in Massachusetts,
You said net less.
right, she would, because the key ingredient is, she would have to buy back, if she worked them in Virginia, as she did, she has to buy back those years. And it's not $4,000, it's more like $25,000, because the MTRS has to come up with a calculation to determine, as per the statute, to determine what those benefits would have, what she would have paid had she worked those years in Massachusetts. So it's a big number. And that reduces essentially the income, the net income that she would have received because she's got to pay that $25,000. Now, she has the use of the $4,000 refund, but it still slants the numbers heavily to the point that she would not have been better off.
What's the hypothetical if there was a double dip?
A double dip, well, I don't think there's a double dip here, Your Honor, because, again,
Yeah, give me an instance where there would be. That's what we're trying to safeguard against, I think. So tell me how that can work out.
I think a double dip would be, back to Justice Massing's point, of even a small number, even a small retirement benefit from Virginia based upon the same years of service, and then getting a second Massachusetts benefit. I think that would be a double dip. And I don't believe we have that here.
All right, your time has expired, and unless I see further questions from the panel, and I do not, thank you very much. Excellent argument. We will hear next from Attorney Curtis Crucell.
Good morning. Thank you, Your Honors. May it please the Court. I'm Lori Curtis Crucell for the Massachusetts Teachers Retirement System, and to my right is David Marks for the Contributory Retirement Appeal Board.
But you're not dividing your time. Okay.
Thank you. At its core, this case is about whether the Commonwealth of Virginia gave Ms. Moynihan monies for the purposes of a retirement allowance, and also ultimately whether CRAB reasonably interpreted 3.4 and the MTRS's clarifying regulation 807 CMR 19042.
All right, let's talk about 19042.
Yes.
The statute says retirement allowance. It says no credit shall be allowed and no payment shall be accepted for any service for which the member shall be entitled to receive a retirement allowance from any other state. You've written a regulation that has the phrase employer contributions in it.
Yes.
That doesn't appear in the statute. If I read this correctly, you're saying that if the retirement plan in Virginia or any other state was like what I understand our retirement plan to be, which is they take a bunch of our salary and put it into something, and at some point we vest, and then we get a pension, a whole pension. Mm-hmm. You're saying that if that's what this Virginia plan was, and she was getting a pension, $42,000 a year or something from Virginia, you would still count these as creditable service.
What the regulation defines, helps us to define, is the purpose that is being put forth.
Could you answer my question? You don't say that's a retirement allowance. A full pension based on employee contributions, that is not a retirement allowance. So you can collect both an out-of-state pension, full pension maybe, and get credit for those years.
The distinction is you could not get credit for those years.
Yes or no?
No.
Why can't you get credit for those years?
Because one period of service is entitled to credit. Either in the Commonwealth, if you're applying for the exception under 3.4, it's an exception to the general rule. Most folks who work outside of the Commonwealth do not get credit and have a Massachusetts public pension for work they performed in Virginia or Montana or wherever. So this is an exception, and under this narrow exception, there are limits. And the limits set forth in the regulation, 1904, says it looks to two questions. Was there at issue a retirement plan? We define it, it's set out in the statute. So you look to whether it was a retirement plan.
A defined benefit plan, not a defined, so 401k doesn't cover 403b, whatever it would be for an educational or state institution, doesn't matter. It's got to be defined benefit, a pension plan, basically.
Well, a defined contribution plan is also in there, but that's not at issue here. Here, we look to the record, and we know that around page 99, that this was a defined benefit plan. So this is similar to the one that you used.
So why, in my hypothetical, don't you get credit? There are no employer contributions used, and it's for any and all years taught out of state. They can buy creditable service.
Because it's covering that service for that same service. So only one period of service. You can't buy back that time. Oh, I'm sorry, I misunderstood. So if you're trying to buy back that time, you can't buy back that time.
Why?
If you want, because our regulation and our 3.4 tells us that the public policy in the proviso in 3.4 limits it. It's a limited exception, and it tells us it has limiting factors. Are you a teacher or are you holding a position that is specified in the statute? Are you working for a school and have you not retired yet? And the big one at issue here is unless you have not received or eligible to receive a retirement allowance from another state.
Just answer my question. Is a pension based on employee contributions only? Is that a retirement allowance under your exception?
No.
Oh, it is not.
No.
So your alleged double-dipping reason here is nonsensical. If it were an employee contribution and now you vested and you're getting $42,000 a year in pension from Virginia, if the contributions had been all employee contributions, they wouldn't be an employment allowance. Doesn't that seem like maybe your regulation isn't right?
Except that this is an exception to the rule, and it's asking that we cover service.
Yes, the exception is an employment allowance. Why would you give someone creditable service for years for which they're already receiving a pension in another state? I don't understand that at all.
So if I understand your scenario, the service that they would be performing in the other state, we're not asking to cover as pensionable in Massachusetts.
I'm sorry, my example isn't complicated at all.
Okay.
They work in Virginia a bunch.
Yep.
Now they work in Massachusetts. They want creditable service for those years. They worked in a school system in another state. So they say, I'll buy the creditable service here to make my pension nice and big here in Massachusetts. And all the contributions to these were employee contributions. And in fact, they did it enough that they have a pension from Virginia. An actual pension will be coming to them. And you'd say, oh, they can buy those.
No, I'm sorry.
I'm sorry, why not?
The key differential here is whether they received an employer-funded.
There is no employer contribution.
Okay, so if there's no employer contributions, then it's like the situation in Connecticut or in Stamford where that was a differentiating factor. Had she...
So you're saying she can collect the pension from Virginia as long as there was no employer contribution, and there wasn't, it was all employee contributions.
Well, not in our circumstances here, it was employer contributions. But if there was just in your hypothetical...
Yes.
Then...
I'm trying to figure out if your regulation is a reasonable construction of the statute, because it has to be, or we don't defer to it.
Right.
It seems unreasonable to me to say you can collect a pension from another state as long as it was just employee contributions going in. That seems to me like you're saying, for some reason, that's not a retirement allowance, when any reasonable person would say that's a retirement allowance, a pension.
Again, I apologize. I don't think I understand your hypothetical because it's just hypothetical, because what we're trying to cover, what we're trying to get at is the regulation prohibits for the same service, the same amount of, that same time, no employer contributions at that same time.
Okay, that's not what the statute says. It doesn't say if an employer has contributed to the other plan, you get no credit, and if not, you can buy credit. That's not what it says. It says retirement allowance in the statute.
Right.
So I'm trying to figure out, and first of all, it seems like you've left out half of the retirement allowances, the ones that are based on employee contributions, like our pensions are. All we do is the Commonwealth doesn't help us with that. We have to pay all of our contributions ourselves. Now let's get to the next part, which is treating a refund of that money as a retirement allowance. Am I correct that if she had left the money in Virginia, and now that she's retiring, she had asked for it out, you'd still count it as a retirement allowance, right?
That's correct.
Okay, so it's got nothing to do with the earliness or the lateness or anything. some employer contributions were put in, and if she gets them out, they're a retirement allowance.
Right.
How can it be that if she's never vested in the plan, and she gets back a refund when she's 23 years old, because she's not going to vest in the plan, she's moving to Connecticut or Massachusetts, why would that be under the words retirement allowance? Like, I don't understand. It's got nothing to do with retirement. She's separated from service and was entitled to get back her contributions, so she got them back. But it's not it's not a defined benefit. What does it have to do with retirement?
Because it was put into a retirement fund for the purpose of retirement contributions, just like we have retirement contributions that we ourselves in Chapter 32, we are required to
Sure,
put
but if
in.
we don't vest, what do we get?
We get those back with interest,
Okay.
a small amount of interest.
Yeah, 0.1%. So we get back our contributions, and you're calling them, for some reason, a retirement allowance. It seems like if you vest, you get a retirement allowance, but if you don't vest, you just get back your contributions. Putting the label retirement allowance on contributions that you get back, I don't get.
The distinction is that it's a retirement allowance available from another employer, from another state. And so there are limiting factors in 3.4. 3.4 doesn't define, you're
She
correct.
didn't retire,
No, she didn't retire, but
and yet she was entitled to the money back.
She took out retirement monies. Those monies were intended for retirement purposes. Virginia covered her 5% as required by Virginia statute. and
I'm
she
going to
was-
read to you from,
In this
well,
case,
go ahead.
it
yeah.
is $4,000, right? In
It's
this case,
it's
it
a
is
small
4,000.
amount, but
So let me ask you two questions. As applied to Ms. Moynihan,
yes.
as applied to her, is that
She
what
was
this
a-
is supposed to be safeguarding against? As applied to her, in this particular situation?
So we look to the regulation. The regulation tells us to look for two things. Was she participating or eligible to participate in a defined plan? Here we know, based on the record and based on her application for these benefits, for the buyback, that she was eligible to participate in the Virginia retirement system. We also know that it's a defined benefit plan.
I get that.
And
I
then
understand the language. I'm trying to figure out the harm.
the harm is that then the Commonwealth of Virginia put in monies to be available for her retirement. And those monies were then able, when she left, to be able to walk away with money in hand.
Yes.
Had she performed them in the Commonwealth, she would not have been able to have that. That's her benefit. And she was able to take that benefit and use it as she saw fit. And that's what the statute is trying to ask us to do. It's a very, it's an
I
exception
just
to the
question,
rule.
I understand that it meets the regulation. I just question what the regulation has to do with the phrase retirement allowance in the statute. I don't think that's a retirement allowance, right? You separate from service long before retiring. It's not a retirement allowance at all.
Except she was given monies for retirement purposes by the employer.
I understand that, but it doesn't say that in the statute. It says retirement allowance.
No,
It
but-
doesn't say any monies deposited in something that wind up not being used for retirement. It says retirement allowance.
You're correct. You make an excellent point. The statute was silent, but what we can infer is the public policy behind this limited proviso, which advances that.
But
Government-
if a person
Massachusetts-
puts their own money in and gets a whole pension, that's okay with you.
Yes, she can put in her own
Right? She puts in
money.
her own money like we do here.
Right.
And then one day she vests, and suddenly she's getting some portion of her Virginia salary every year for the rest of her life. But you don't call that double dipping, even though it obviously is. She can buy those years of service here. She gets credit in 2 states for them. Doesn't it seem like maybe that's not what the statute had in mind?
I agree, and I am concerned I'm misunderstanding your
The double dip that Ms. Moynihan.
The double dip is the sum,
She got the use of the
that she
$4
got,
grand.
the money in hand
Yeah.
that she was able to use, that somebody similarly situated in Massachusetts would not have received those
That's not really
benefits.
double dipping, is it?
What's that?
That's not really double dipping.
Covering the same amount of service, covering that
Pay that
same
money back
time,
in.
she got that money.
So she's going to pay it back in. She's not keeping that money and have the benefit of it. She's going to as I understand the record, she's going to use that same $4,000 and pay it back in. She wants to buy it back.
As the cases have talked about, it's not what she does with that money that's important, it's the employer contribution that is what's being prohibited here. We don't want her to get contributions for retirement purposes from another state, and then the Commonwealth then take on
Retirement
that service.
purposes, that's why she got the $4,000? It's
did.
not because she separated before retiring and wasn't going to get a retirement allowance?
That's the key. The money was for retirement purposes.
Okay,
It
now
was
I'm
a
going to read to you
retirement fund.
from the Virginia, the pamphlet or whatever this is in the record about the VRS plan. Vesting is the minimum length of creditable service needed to qualify for a retirement benefit. You become vested when you have at least 5 years, 60 months of creditable service. Once you are vested, you are eligible for a retirement benefit if you meet the age and service requirements for your plan. Now, I understand that's the state of Virginia, and we don't have to go by their definition of retirement benefit. But surely it's reasonable to understand that when you get back money having not vested, you aren't getting a retirement benefit at all.
Except 3.4 doesn't talk about vesting. 3.4 instead gives us this unless proviso. This
Yes,
limiting
employing a
proviso.
retirement allowance.
And the money that she received in Virginia was for retirement purposes. It was put in her retirement account. It is for the purposes she was participating in retirement account paid for with employer funds. And that's the limiting factor here. That's what we're trying to do with the double dipping, is to prevent the service that we're going to pick up here that was performed outside of our Commonwealth, that doesn't benefit our Commonwealth students. This service cannot it has limiting factors. And one of those factors is that she cannot have had employer contributions into her retirement account. It doesn't say, and she's trying to carve out an unwritten rule that it's vesting is required or lump sums aren't required. It's simply the factor that it's at issue here is, did the employer contribute funds for retirement purposes? And then, because remember, 3.4 is an exception. It's an exception to the rule, and it's limited. And so we believe that it is a reasonable and consistently interpreted application, and that our regulation helps to clarify, standardize, and define what a retirement allowance is.
Just for my own benefit, do you happen to know what the difference would be, excuse me, if she got the 4 years credited in Mass, what the difference in her I don't know what to call it, pension, retirement allowance, you call
Right.
it.
In her service, it would increase, that would increase
How much?
her, I'm not sure the exact amount. It's not, it's significant. You know, years of service are one of the factors that we use to calculate a retirement
She
allowance.
said she would get 30 if she had these 4 years and won't without. How much difference is that?
I don't know. I'm sorry, Your Honor.
Okay, your time has expired. Thank you for an interesting and excellent argument. A very, at least for us, complicated case. I'm not sure that it is. The case is submitted.
Thank you, Your Honor. Excuse me.
It's a strangely popular case.
People are all here for this. I didn't know that Crab had such a
Yeah,
constituency.
exactly. It's these crab cases that get these huge audiences in here. We will, except for every other time we've heard one, we will hear next number 22-1006, Long versus Massachusetts Department of Conservation and Recreation, and another. And I believe we will hear first from Attorney Pinto.
Thank you. Your Honor, good afternoon. May it please the court, Donald Pinto for the plaintiff trustees. As regards record title, this case went to trial on one issue, which was the Commonwealth's claim that the Hatch to Higgins deed was never delivered and accepted, and therefore title never passed to Higgins. The land court, in a pretty thorough analysis, rejected that claim, said not only was that deed delivered and accepted, but it was effective to pass title to Higgins. So that was the state of the record title for 150 years until the land court in 2022.
Well, except it wasn't, except nobody thought, everybody thought that the operative document nobody knew about that document until the trial came. So it wasn't exactly the state of the evidence for 140 years. That was unknown for 140 years.
Well, it was unknown only because nobody knew it. It was sitting at the Registry of Deeds. It was on record.
How do you win if you own the record title? A railroad had exclusive use of this strip for about 100 years. Why didn't they get it by adverse possession? Why are we here?
Your Honor, it wasn't exclusive use. The train
It
tracks
wasn't?
No.
If I find you a statute that says it's illegal to cross train tracks, would it have been exclusive use then?
I don't know. Under property law, I think for it to be exclusive use in the adverse possession sense, it would have to be confined, fenced in some fashion.
I don't think you have to put a fence up. I think a railroad track where people can get killed crossing it might well create adverse possession.
Your Honor,
maintaining the roadbed, putting down tracks. There's those ties that have to be every couple of inches, I think. I don't know, less than a foot between them. I don't understand why, how you think that you would still have title 145 years later.
Your Honor, this was 1870 in
I
a
agree with that.
rural area. The trains, and there's some evidence in the record of this, ran twice a day. So other than the...
Yeah, but it's probably illegal. I'm sure I can find a federal statute making it illegal to cross railroad tracks. That's a dangerous thing.
I don't know that in
You don't know if
1870 there was a statute making it illegal to cross
I would think
railroad
from about
tracks.
1850 there would have been statutes like that.
Yeah, I'm not aware of that, Your Honor, and there certainly was...
So you think there's no adverse possession here?
Correct, Your Honor.
You concede prescriptive easement.
Yeah, we do, Your Honor. Absolutely concede the prescriptive easement, just not adverse possession in the exclusive sense.
How would we
because
figure out if it was exclusive or not for the 20 years from 1870 to 1890?
I would suggest it would have to be fenced or enclosed in some fashion.
Do you know that it
Otherwise,
was or wasn't?
There was no trial evidence that it was enclosed. That was something we
And so
looked at.
the burden, though, you think would be on the department?
Yes.
Huh. So you can wait 145 years to raise a claim. You don't think it's barred by latches. There's no evidence left because you've sat on your rights for 145 years. I really don't understand. I mean, I understand you want to have that property be worth more than it is, but I really don't understand. You didn't even know, allegedly, that you had a claim to title to this thing until about, whatever, less than 2 years ago.
That's correct, Your Honor.
So I don't understand. You rest on your rights for 145 years. Why latches don't bar you from challenging the other deed under which everyone has operated, the railroad, the town, you, all other abutting landowners, for 145 years. You act like this happened yesterday, and it happened 145 years ago.
Your Honor, nobody knew about the deed, so there was no resting on
I
rights.
disagree. Failure to find the deed is resting on your rights.
Well, then the Commonwealth rested on its rights, too.
No, the Commonwealth hasn't rested on its rights at all. It thought that deed was, the deed from Hatch to the railroad was good. There was some evidence that it was. Let me think. A railroad ran there for 90 years.
Right.
Right, and then
The railroad could have found out that its deed wasn't good by just going to the Registry of Deeds and finding the deed
Can I ask
that
you
we
a
now
question
found much
about
later.
this? Suppose, let's go back to its, let's go back to the Hatch to Higgins deed. So suppose Higgins actually, which makes Hatch's deeding the strip to the railroad impossible. How do your clients come to own the strip of land? Because there's the 1874 deed. Higgins, he deeds out everything but the railroad line. How do your clients come to own the railroad line.
Your Honor, in that 1874 deed, the two separate parcels were conveyed, and then there was a catch-all provision in that deed saying, meaning and intending to convey all.
Yeah, but you know the usual rule, right?
Pardon?
You know the usual rule when there's a meets and bounds description, even if there's a catch-all,
Right.
is that it covers the meets and bounds description.
Right. In this case, the catch-all was critical because.
So we have to
referred
construe
back
what
to-
it means if latches don't bar you from challenging the 1871 deed anyway.
Your Honor, laches was not an issue at trial and not an issue that was decided by
Can't
the land court.
stipulate the law.
Pardon?
You can't stipulate to the law. We're going to let people with 145-year-old claims start coming in. You're arguing that you can't, if it goes the other way, you're arguing they can't find a road. Well, maybe if one of your predecessors in interest had actually said they were landlocked, then maybe they would have found a road. They all thought the railroad owned the property, but for 145 years, no one said anything. I mean, I find acting is like this universe in which we pretend 145 years hasn't passed to be a very strange way of litigating a case. And I credit you for thinking of it, and I guess I don't credit the department for failing to really press the point, but 145 years later you come in and say, listen, that deed was no good, and everyone has relied on that deed for 145 years, but I'm here to say there has to be an at-grade crossing here, and there should have been one. The railroad didn't build one for 100 years, but that's what there should have been. It just seems really odd to me.
Your Honor, laches, like the land court's other equitable theories that, well, maybe there was a reformation or should have been a reformation of the Hatch to Higgins deed, or maybe there's an estoppel. None of that was tried, and we would have tried a very different case if we were aware that those equitable issues were at play. And we certainly would have looked into the railroad's
Do you think adverse
responsibility.
possession is at play?
Adverse possession? I
Because
don't.
if your deed is the good deed, and I have to say, I think Judge Massing brings up a very interesting point, which is, who is the successor to Hatch? Does anyone know?
The successor to Hatch was Higgins. The successor to Higgins was John Wiley, who's the
Well, but
predecessor
with respect to the parcels, but who would be Higgins' successor if we read that deed to only give the two parcels? Who would be Higgins' successor with respect to the strip?
Well, if you posit that the catch-all clause does not convey title to the strip, then I don't think we know who the successors would be. But we relied on the catch-all provision that the intent of the parties was to convey everything that Stephen Hatch previously owned.
Kind of hard to know the intent. It was 145 years ago.
Your Honor, again, that takes me back to the equitable concepts that the land court seemed to rely on, which was news to us. This was post-trial. It was not pled. It was not briefed. It was not argued. I would have conducted the trial differently. I would have tried to reduce evidence.
And I don't know why the department, I'll ask, why the department hasn't pressed any of these points if they haven't. It seems very odd to me to be talking about what a deed from 145 years ago that no one knew existed.
Your Honor, in terms of laches or reformation or estoppel, at bottom, all of those claims would require the court to determine that the railroad company, and now the Commonwealth, was entitled to equity, deserved equity, didn't fall down on its own job. The railroad was in the business of acquiring strips of land. The railroad could have gone to the Registry of Deeds, found the Hatch to Higgins deed, and said, oh, we don't need to deal with Hatch, we need to get a deed from Higgins. They didn't do that. And so they don't come to equity with clean hands or having.
So if the Higgins deed, though, doesn't include the strip, then some successor to Higgins maybe has record title to it.
Correct, Your Honor. But we also have our easement by necessity argument.
Now, let's talk about the easement by necessity argument and equity. Although I interrupt, you have a question.
Sure, I was just curious. One of the things you quarrel with is that Judge Piper seemed to go back a little further in time than even 1870 to determine whether or not there were these roads or cartways or whatever. You say he shouldn't have done that.
The law is that he's supposed to focus on the time of severance, which was 1871. He went well before that to deeds from 1802 and 3. But if you look at those deeds, they just mention as a boundary of a very vaguely described parcel that there was a cartway. And he put apparently a lot of stock in that as showing that there was alternative access. But our main beef with that is that he didn't give the trustees the benefit of the presumption of law that there was an easement by necessity, and then put the burden on the Commonwealth to prove that there was alternative access. And the record is barren of any persuasive evidence that there were cartways that provided access from parcel 2 and the theory was that there was a road from the northeast corner. The Commonwealth's own expert said to the northeast corner of the Hatch parcel 2 was swampland, so the road couldn't have gone there.
If only you brought this suit sometime in 1875 or 85 or 95 or 1905 or 1915 or 1925 or 1935, maybe there would be better evidence on the ground, but you didn't bring it until now.
Your Honor, this is not uncommon, that easements
It's a little
by necessity.
uncommon.
Well, we had the Kittredge decision, which is kind of the leading case on easements by necessity, was similarly looking back 100 years. But the evidence in that case, the contrast is stark with the evidence here. In Kittredge, there was extensive evidence.
I mean, again, I'm not at all sure why. And why wouldn't the railroad coming and going over your alleged easement for 100 years extinguish it if they had exclusive use of the strip of land and there was no crossing there, nothing built?
There is no exclusive use. There was no fencing. There was no reason why.
How do you know there's no fencing? It was 150 years ago.
Well, the Commonwealth looked into it. There are some photographs in the record of the Wellfleet station, and you can see some extent of the tracks on both sides of the station, and there was no fencing. And I think fencing just wasn't a common thing when the railroads first began in the late 1800s. And in the absence of fencing,
What year did the railroad run until?
I think to the 1960s.
Huh, were there fences then?
I don't think the record shows that, and I don't know whether there were or not in this particular location in rural Wellfleet.
I don't know either.
I mean, today's commuter rail is not extensively fenced. I have one running through my town, and there are, near the grade crossings, there might be a section of fence, and then the other areas are open.
All right.
But Mr. Hatch, the train went by in the morning at, say, 9:30 in the morning. The next train wasn't until 5 p.m.
So he's illegally crossing?
Well, Your Honor's positing that there's a statute that makes it illegal, and I don't think in 1870...
Well, I think that when the railroads started being built, lots of statutes were put in place to protect the railroads. And I'm guessing, since people get killed crossing the tracks, that we could find one that said you can't cross the tracks.
Yeah, again, I think in 1870 in rural Wellfleet, it was a different story. The railroads were fairly new.
Yeah, but the laws of Massachusetts applied in Wellfleet even back then.
They do, Your Honor. I'm just saying, after 9 in the morning, when Mr. Hatch waited for the morning train to go by, he knew he had the next 8 hours that he could walk across those tracks.
And if it was illegal, though?
Pardon?
If it were illegal,
yes,
then he can't cross.
Well, he could, in fact, cross illegally. I'm just saying.
Can you get adverse possession?
Well, adverse possession turns on typically physical obstruction, physical barriers, fencing, and if in the absence of that, whether it's legal or not, I don't think is important if Mr. Hatch was able to visit the other side of his land at will, except for the 3 minutes that the train was coming by twice a day.
Go ahead, no? You got a minute?
No other questions?
Well, I don't know.
I'll rest on my brief.
All right, thank you very much.
Thank you.
We will hear now from Attorney Kinshirf.
Good afternoon, may it please the court. My name is Kendra Kinshirf. I represent the Commonwealth and the Department of Conservation and Recreation. I first would like to correct the record. Latches absolutely was tried. And if you look at volume 3 of the appendix at page 253, Attorney Pinto addressed Latches in his closing arguments because it was tried. It was alleged by the Commonwealth. It was part of the trial. the Commonwealth also alleged estoppel in its affirmative defenses. The plaintiffs never amended their complaint throughout the entire proceedings, and so that affirmative defense was still at issue. But as Your Honors have mentioned, in 1871, Stephen Hatch purported to convey the disputed strip to the railroad company. All of the plaintiffs' predecessors and the plaintiffs themselves for 150 years recognized fee title was in the railroad company and then subsequently in the Commonwealth. And they asked this court to change that 150 years. But as the land court correctly held, they are stopped from doing so. This court has the power to affirm the land court's decision on that based on estoppel in pais, which is also an equitable estoppel. The land court directly invoked that theory when it cited Amidst versus White in its decision. Now, I will concede that the land court did not go through each of the elements of estoppel in its decision, but it made all of the necessary factual findings to reach estoppel in its discussion of the four transactions that were at issue here. As you're all well aware, estoppel requires a representation.
You didn't argue that if, in fact, the good deed is the one, using the catch-all provision from the 1870, what is it? That's the 1874. Now I'm getting confused.
Yes, that's the 1874 deed.
So if indeed this property has passed through all the successors to Wiley, to the trustees, you didn't argue that it was extinguished by having a railroad go through it for 100 years? Why?
There is case law that suggests that at most, a railroad company would get adverse possession of an easement and not fee title, and that's why I didn't argue that. Conversely, there is very much a statute that does make it illegal to cross railroad tracks.
But there's case law saying that a railroad going through your property does not obtain by adverse possession the property.
It obtains adverse possession of an easement, but
and
not fee.
what does Massachusetts obtain by putting a bike path there for the last however many years?
We claimed that if they hold fee title, that we own an easement by adverse possession.
You
which
don't think you own the property by adverse possession?
I'm sorry, what was that?
You don't think you own the strip? You think that you have an easement if it's their property? You don't think that what you're doing there is exclusive, open, notorious for more than 20 years?
The Commonwealth is exclusively possessing that area and inviting the public.
But you've said that it's just an easement you get. You haven't claimed that that gives you ownership of the property by adverse possession. Your exclusive, open, and notorious use of that whole area, including for whatever, maintenance and so on, that only gives you an easement.
That's what we claimed at trial, yes.
Do you know why? Is there a reason you don't get adverse possession of all that land?
I think because we were looking at the law of the railroad uses, and railroad uses only give rise to...
What year did Massachusetts start having a bike path there?
They started in, I believe it was the 90s.
Okay, so it's been more than 20 years.
Correct, and the plaintiffs concede that we have established adverse possession.
Of an easement.
Yes. But for the issue of estoppel, the plaintiffs are arguing that there can never be estoppel when it pertains to real estate because one can always go to the Registry of Deeds and look up the title. But that has already been decided against them. The SJC and this court in Amidst versus White has applied estoppel to real estate. And they have conclusively stated that where one having title acquiesces in the disposition of property for valuable consideration by a person pretending to have title, they cannot later claim title to it. That is exactly what has happened here. In 1870, Hatch agreed to sell a strip to the railroad company. Based upon that representation, the railroad company came in and constructed the railroad. And again, in
The railroad was constructed before that, right?
No, so there are two separate transactions. The first transaction, Hatch gives an agreement and a license, and that is at exhibit.
Wait, this is the option, the $200 option to purchase a right?
It was an agreement to purchase, but it was also a license to enter the property.
To build the railroad?
To build the railroad, yes. And that is at exhibit 5, I believe.
So for no money, he let them
Was
build
for
a
$1.
railroad?
The agreement was for $1 to sell the strip and to allow the railroad company to come in to survey, to construct the railroad. The reason why they do that is because sometimes the railroad needs to relocate it a little bit because of geography.
Wouldn't you usually say, and if you build a railroad, I mean, coming to survey is one thing. Building a railroad across your land seems like something else entirely. Seems like you'd want to get paid before someone did that.
It was being held in escrow, and so that agreement specifically
The
states,
$200 was held in escrow?
that agreement states that if they lay the railroad tracks down, Hatch is going to convey fee title to that, and you will get $200.
What do you make of that never happening?
Hatch did convey the railroad, but for $125.
Why?
We don't know why. It may be that it was a different area, total area, than was
It bisected
previously
his property. The
contemplated.
problem with the railroad is it cuts it in two. Not that it's too wide or too narrow, right? And the value of it to the railroad is the same whether it's got to go this way or that way or...
No, the amount of compensation that you receive for the strip of land is based upon the square footage of that land.
If it's
They had
taken-
alternative,
I see. They had an alternative of the eminent domain.
access.
I see.
And so they did not need to cross that railroad track because they had alternative access. The evidence at trial was very clear, and contrary to their arguments, it not only was the earlier deeds, which are describing the cart paths not only on accessing the northeast portion of the property, but it also the abutting owners reference those cart paths. And in fact, in Exhibit 6, the 1874 deed to Wiley, it also references haying in the uplands of the property and the ability to get there by the roads. And so it's a recognition that those roads still existed.
Whose burden did the judge make it to prove this?
The burden is always with the plaintiffs. The plaintiffs have the burden of proof. Kittredge is very clear that the presumption only arises if you first establish that the parcel does not have access. And then if you have that presumption, then the presumption shifts the burden of persuasion, not proof, to the Commonwealth in order to rebut that presumption, which the land court said, even if the presumption holds here, I find that the Commonwealth provided sufficient evidence at trial to rebut that presumption. And so they are incorrect that the land court did not provide them with that presumption. The land court found in both scenarios, either you didn't meet your initial burden, or if you did, the Commonwealth did enough to rebut it. And when faced with that evidence on day 2 of the trial, they came into the trial and said, we are not going to address the cart paths or the deeds from in Exhibit 62 through 65. They left it alone. And so the state of the evidence was that there were access to Parcel 2 at the time of the severance. And so there is no easement by necessity. The land court's findings of fact on that are well supported by the record and must be upheld. And the findings of fact with respect to estoppel are also well supported by the record.
Can I ask you about you're relying on the estoppel. Judge Piper went through a lot of time saying that even that, yes, I find that the deed was the 1870 was delivered, but it can't mean what it said, and I'm going to read them all together, and this is what I think they all mean all together. Are you distancing yourself from that?
No, so actually, it is actually a very, so Judge Piper looked at the 1874 deed, and as you've recognized, it clearly, and even the plaintiff's own expert says that evidence is a clear intent not to convey fee title to the railroad company. And so that gives rise to what is going on here? What did the parties intend? And in order to look at that, the land court looked at the surrounding circumstances, which does include those previous
But what do you make of the meaning to convey everything that, I guess it's Higgins has in the 1874 deed?
But no, it meant to convey Hatch's land, and Hatch himself purported to convey the strip to the railroad company. So in 1874, when Higgins, his son-in-law, who knew what Hatch had done previously, was conveying out Hatch's remaining land after his death, he was saying, I'm conveying these parcels. I'm not conveying this disputed strip because it was already conveyed to the railroad company. And he acquiesced in that and recognized it by even the plaintiff's own expert's opinion.
But doesn't that clause suggest that if he was mistaken, well, now I don't remember who, I'm getting confused about which is Hatch and which is Higgins.
Let me get back to my, just kind of, my question, which is, so could we affirm on the basis of this is what they all meant, as opposed to having to go and find a new, and find our own equitable estoppel theory?
Your honors are able to affirm on any theory,
right, yeah,
even those that were not before the land court.
Saying the one that the land court actually relied on.
The land court did rely on the fact that 1874 deed showed a clear intent not to convey the strip. And in order to understand whether or not it did in fact convey the strip, he looked at all of the four transactions together, and that confirmed to him that the intent of the parties was not to convey the railroad strip to Wiley because it had already been conveyed to the railroad.
Does the law permit him to do that kind of analysis?
Yes, the law permitted him to do that because it is based on estoppel. The land court set up...
But you can't do it without estoppel.
I'm sorry, what was that?
You can't answer that question by saying yes, but he doesn't need to rely on estoppel. I'm trying to, I said, does the case law allow what he did? And you said, estoppel. I said, does it without estoppel?
Does the law allow him to decide it based on estoppel, or does the law?
No, based on just his construction of the deeds.
Yes, so in effect, he's saying that the 1874 deed was ambiguous as to whether or not fee was being transferred to Wiley. And so when there is an ambiguity, because there is it's describing it as separate parcels. Instead, as both experts agreed, had they still retained the fee, it would have been described like it was in the 1830 deed as a single parcel encumbered by the railroad. Instead, it conveys it as separate parcels, and those separate parcels, the deed notes, are unencumbered by anything. And so it is recognizing that the railroad company owns fee. Our property that we're giving to Wiley is not encumbered by the railroad track.
Okay, but if Higgins was mistaken, and in fact, although he described two parcels and thought that was all that was left, thought, well, this has been conveyed to the railroad, if he was mistaken, and in fact still had an interest in that part in the middle, and he wrote in the deed, meaning to convey everything, do we read that to include the mistaken, the one he thought, just like everyone thought for the next 150 years, had already been conveyed to the railroad? Does that catch-all phrase mean, and so it's conveyed to Wiley too?
No, because as you indicated previously, the more specific would govern over the generic. However, I will concede, it hasn't been raised, but it was raised below, that the derelict fee statute applies to railroads. And so because it is bounded by the railroad tracks, then it would convey fee title along with it, even if it's mistakenly not included.
This strip is a public way.
Yes. There is case law.
Since when?
There is a wealth of cases that apply the derelict fee statute to railroads.
Even when the land underneath the railroad is owned in fee by?
No. It's only if it is owned by an easement. If it is owned in fee, then like the deed in Exhibit 6, you are separating out the two parcels, and the railroad owns the fee. It is a matter of interpretation that the law doesn't want this missing parcel to just be hanging out there, and so if it is an easement, the fee is still retained by the abutting owners.
Unless, of course, there's language specifically reserving it.
Yes, there does have to be language specifically reserving it. We had a case on that matter together recently. Your time has expired.
The only thing that I would mention, again, as I started out in the beginning, is that laches was argued at trial.
Yes, we heard you
and would be a separate basis.
at the outset. Thank you very much. Excellent arguments by both of you. A very complicated case, and it is submitted. The final matter we will be hearing this morning is number 23-111. I have little doubt that I will mispronounce the plaintiff's name, but I'm going to say Faze versus MBTA. I gather that appellants will be dividing their argument between two counsel, 7.5 minutes each. Is that right?
Fine, Judge. Thank you.
And we will hear first from Attorney Mills.
Yes, proceed, Your Honor.
Please.
Good afternoon, Justices. Mr. Bonasali and I will share our time through the courtesy of COVID, which prevented Jennifer Lee from arguing this case. I will address the standard of review in this case, and Mr. Bonasali will argue that the plaintiff's claim is essentially exempted by the statute, 258, Section 10. We'll keep referring to the statute, and that's the statute. And he will argue that the complainant must prove that the MBTA affirmatively acted to originally cause the violent conduct. This case involves an altercation during a snowstorm at the bus stop in Lynn in 2015 when Mr. Thies and the bus driver, who has essentially defaulted and does not appear in this case, got into an altercation. Fighting words were exchanged, and the bus driver assaulted Plaintiff Thies and caused serious injury, which is admitted as part of this case. The plaintiff first complained in Superior Court, and on motion for summary judgment, the motion judge entered judgment for the MBTA on the vicarious liability claim, ruling that the MBTA was not vicariously liable for the actions of Thies. This is the law of the case. Yeah, we argue as to the vicarious liability claim. Subsequently, the complaint was amended, and the summary judgment request was rebrought, and the judge denied the motion for summary judgment, and we're here on the doctrine of, what is it called, present execution. And there's a problem with respect to the standard of review, which historically in this court has, I don't believe, has been specifically addressed as to the language, especially as it pertains to this case. I looked to find a case in which the court denied a motion for summary judgment, and it was brought up here to find out what standard of review, and I couldn't find one. Could find lots of cases, both at the SJC and here, where summary judgment was allowed, and the court was then looking to see what the evidence was to substantiate the allowance. In this case...
So wouldn't it be denied if there were just material facts in dispute?
Sorry, Judge?
Wouldn't summary judgment just be denied if there were material facts in dispute?
Sorry, I still couldn't hear you.
Yeah, the question is whether... the microphone
Sorry,
maybe.
let me try the mic too. If there were material facts in dispute, wouldn't that negate any finding of summary judgment?
Yeah, it would indeed, but there is, of course, the argument of the MBTA that there are no material facts in dispute.
But with respect to the standard...
Well, the standard, I'm talking about the standard now for this court's review of this denial of a motion for summary judgment.
You think we should give deference? Isn't it de novo?
On this record, which is a bit of a shambles, and I will try to explain.
It's de novo, isn't it? Why isn't it de novo? It's always de novo.
Yes, it is de novo.
Okay.
Your review is de novo on the basis of what factual predicate? In other words, below, the motion judge permitted the plaintiff to file a document called Additional Statement of Facts, which is something explicitly not permitted by our Superior Court rule. And the judge then transformed the illicit statement of material facts into a request for admissions, not requested by the plaintiff, a request for admissions under Rule 36, which then became proven as to the plaintiff's claim.
Well, not...
So what facts are you particularly troubled by?
Troubled by all of the facts that are contained in the illicit pleading entitled Admission of Facts, and...
Well, if I recall off the top of my head, there were like 30 of them, I think, right? 15 of them happened prior to termination, and then several others happened after termination. Is that right?
From our count, there are 30 facts, 15 pertaining to behavior before the promotion date.
So would you say that's all okay? Because this is, he shouldn't have been promoted, right? You're saying the issue here, as I understand it, is his being promoted from part-time to full-time. Had they not promoted him from part-time to full-time, then this may never have happened. I'm not really sure how that works, but is that the argument?
I'm glad. I really think that you have the chronology down, and it's important. But the thing is, the 30 statements of fact have no place in the record of this court for purposes of part of the factual predicate.
Are they supported by record evidence?
No, they are not, Your
There's no affidavit they refer to, or deposition, or any document attached to an affidavit or something?
No, I couldn't find them substantiated. Huh. And further, throughout the pleadings before the motion judge and the brief filed in this court by the plaintiff, two-thirds of the assertions of fact and citations to law have no record evidence. That makes it a nightmare for any appellate counsel attempting to brief to this court, and I can't speak for you, may make it a nightmare for you to decide what facts are the factual predicate for you to review in comparison to the law. So there is also 4 videotapes that are in the bucket there. They're in the bucket that came to this court. One of them is a videotape of a Fox News episode in which an unidentified woman makes an opinion as to the liability in this case. I must scratch my head. Now, how did it get there? Why is it there? And how is it here? And is it part of the record before this court on summary judgment review? I looked for some language in our cases and the SJC. Am I out of time already? Oh, for heavens. For purposes of the argument on the rest of my argument, I hope, is competently presented in the brief, and Mr. Bonastoli will
And you're
continue.
essentially arguing that the admissions were in violation of Rule 9A, and therefore, well, I'm calling them admissions, so.
Yes, sir.
I forget what the name of the document is, but that they submitted along with the videos. All that was in violation of Rule 9A, and so we shouldn't consider it.
And beyond that, with no notice to the defendant to be able to respond, to be considered admissions under Rule 36, which was never mentioned by the plaintiff, was not part of the case, and then those to apply, I guess, boggles my mind how that can happen. Thank you.
All right, your time has expired. Thank you very much. Excellent argument. We will hear now from Attorney Bonastoli.
Good afternoon, Your Honors. That's why Mr. Mills and I were disappointed Jennifer Lee couldn't be here because she's got it all on her fingertips. To answer some of the questions, there may be references in the record to a number of the things. For example, I think there's clearly a reference in the record to this the Bergeron event that happened I think 2 years after his promotion. There's references to the videos. And I'm not even sure if it matters if this court on de novo says, even though judge of the Superior Court said they clearly didn't comply with the rule, it's clearly wrong, it clearly shouldn't be in it, and those additional facts shouldn't be considered. Even if you consider them, I'm not sure it matters, because they were put in to sort of inflame the circumstances, to sort of, escalate the drama of it. But
maybe we should get to the merits then, and off of the procedural piece, because you have limited time.
Okay, yeah. Well, it seems like that there.
And let me just get right to the point. The plaintiffs say all of the cases you rely on for 10J are third persons who are not employees of the public employer. How do you respond to that?
I respond again, I apologize for not having it in hand. In my conversation with Attorney Lee, she says there are clearly cases that indicate that it doesn't matter that it's a third party. It could be a direct party that also is protected.
Do you have any in your brief?
I believe there absolutely is. I apologize for not having it. And
one of them is the case where the lifeguards on the beach, right, where the lifeguards were supposed to work until a certain hour, and then they had prematurely left, and the lady's son drowned, and they weren't there.
Yes. Yeah, they were employees.
They were employees.
Yes.
Right?
Yeah.
But here, was he acting in his position as a bus driver when he gets off the bus and chases thieves down?
I clearly don't think so. I was at the argument down below when this came up, and the judge got into the whole thing about that. He was on his clock. He was in uniform. He was a bus driver. But that gets back to what he did was an intentional tort. It's not within the scope of his employment to get into a fight with somebody who's running down the bus and knocking on the doors and asking for directions.
But isn't he the MBTA?
Well, he is an employee. He clearly is.
He's wearing the badge, he's got the hat, he's got the thing, he's on a bus, he's driving it on a route.
Okay, and I remember down below, and I think it's Judge Pham said, yeah, well, that's like the police officers who, in uniform, in a police car, and they go on a chase and go 75 miles an hour and get into an accident.
Yeah, that's the exact example I was going to give.
Well, that's negligence. That's not an intentional tort. You know, that's not.
If there's a policy of the town and they violate it by doing a high-speed chase, I'm not sure how you characterize it, but we're not under the, right, isn't there, I thought there was an intentional tort,
11C.
yeah,
That
and
has
we're
already
not,
been acted on.
10C, we're not talking about that, we're talking about 10J.
Right, but you can't wipe out 10C by saying in 10J, he was acting within the scope of
Well, but now
his
the
employment.
suit is not about the intentional tort, right? The complaint changes the claim to be negligence in hiring, supervision, and training. So that's what they're saying. I'm not saying on the merits they would win,
Yeah.
but they're saying that's the actionable tort here. It's this negligent doing things, and it results in your guy, bus driver Smith, going crazy just like he did with Bergeron and punching someone's lights out.
Why couldn't he do that as a part-time employee? How does it, help me understand the difference between him being a part-time employee and a full-time employee that makes a difference on the facts of this case?
It makes no difference. I mean, he was hired in December 13th of 2010. He stayed as a part-time employee until March 23rd of 2013. He then was promoted to full-time and transferred to Lynn. And then from Lynn, he was transferred to Charlestown and then back to Lynn. The fact that he was a full-time employee versus a part-time employee, there's no connection to him being there that day only because he was promoted 2 years before.
Well, I mean, we're going to have to ask opposing counsel whether that's the critical piece of their argument. What I'm interested in, at least for the moment, is the judge below said that viewing the evidence in the light most favorable to the plaintiff, one could find that, well, actually, this is actually about Section 2. On the merits, one could find that he was acting within the scope of his employment because maybe he was trying to keep the bus on schedule and didn't like the guy interfering with it or whatever. But that's about the merits. Here we're just talking about, is there immunity? Right? Just because there's no immunity doesn't mean the MBTA loses. It might be that this guy was doing something totally unforeseen and unforeseeable, and as a consequence, the MBTA isn't liable on the merits. We're trying to figure out if you're immune under 10J from even having to answer the claim.
That's clearly what we're arguing.
Sure.
And then, the best arguments for us are the statute, which provides, what is not included, based on the failure to act, based on the failure to prevent, based on the failure to diminish, based on the failure to not fire him, in the Bergeron matter or any other things. So the statute, it's not originally caused by the MBTA.
Do you have a 10J case in which scope of the employment is the critical factor? Not a merits case about torts, but a 10J case, because the judge below found, if I can find his language here, the affirmative conduct by Smith is sufficient to satisfy the original cause requirement of 10J. And 10J, of course, says that it's the act of, I thought it was of the public employer or someone acting on its behalf. And I'm just trying to figure out why, if this guy in the middle of his bus route, wearing the hat, wearing the jacket, goes and does something, he's not the public employer doing it.
Well,
It might be outside the scope of his employment, but I haven't seen a 10J case that turns on that.
Again, I apologize, I don't have those cases. I know the brief is very well written. I know the statute is very favorable to us, and the ultimate question is, must have materially contributed to the specific situation that resulted in the harm. Hiring him as a full-time person did not create the situation that happened on March 13th of 2015.
No, but that's a different question. That's about the liability in tort. I'm just trying to figure out if he was the MBTA on that day when he punched someone.
Well, he certainly was on the job. He certainly was in uniform. He certainly was on his assignment. But when he becomes a criminal, it's not within the scope of his employment. When he leaves the bus,
Did he walk back on the bus and finish driving his route?
He did. He did.
What about the affirmative act of promoting him? So now it's not a failure anymore. It's an affirmative act knowing his history.
Affirmative act, but knowing his history means that we should have fired him. And that's a failure to act. Knowing his act, should not have promoted him? Should we have fired him? Even in the Bergeron event that they bring in as sort of his history, a very different case. He got beat up on the bus. Now, granted, he should have stopped the bus, but he got punched and assaulted by the patron that day. So the affirmative act here, they allege, is the hiring of him, or the retention of him is what they argue is the affirmative act here. And the cases all talk about it being too remote in time. This is 2 years beforehand to be.
All right. I see your time has expired, and seeing no further questions, thank you very much for an excellent argument. We will hear from Attorney Federico.
Good afternoon. Justice Rubin, Justice Massing, Justice Desmond. May it please the court. My name's Frank Federico. I'm a partner at Chef and Cook just across the street here. I'm here today with my associate, Mike Holden. I'm proud to represent Matthew Thies. And unlike the disability that my co-counsel suffers from, I've been involved in this case from the very beginning, and I think I have all the stuff underneath my own fingernails. So I'm going to give you what I view the case to be about. Despite the procedural wranglings that have occurred throughout the tenure of this case, the case is a very simple one at this point. The case is against the MBTA. The case is against the MBTA for their negligence in retaining, promoting, and keeping a dangerous person and putting him in the course of a bus driver tendered with the responsibility and safety of the passengers of the MBTA. That's what the case is about. The incident occurred in March. I'm sorry, Judge.
Let me ask you this question. Some of the incidences that you point to, he didn't come to a full stop on one occasion when they were monitoring him, and he should have come to a full stop, right? Or he didn't stop when some folks were trying to wave him down and stop the bus. All of that seems to be consistent with your obligation as a bus driver, or certainly pertinent to your business as a bus driver. But getting off of the bus and chasing somebody down, how is that within the...
Not about the bus driver, Judge. This is not about the bus driver. This is about the MBTA. Everything that we mentioned in our brief, 12-13-10, he's hired. 9-20-11, he leaves his station early, is reprimanded by his supervisor. 10-12-11...
I'm sorry, I just want to talk about 10J.
Okay.
Why aren't they immune?
10J doesn't apply to this case in
Why?
any way, shape, or form.
Okay, go ahead.
A plain reading of the statute simply says, a public employer is immune from liability for any claim based on an act or failure to act or prevent or diminish the harmful consequences or conditions or situation, including the violent or tortious conduct of a third party, which isn't here, which is not originally caused by the public employer or any other person acting on behalf of the public employer.
But they're saying, I think, and I'm not sure they really say this, but they're saying once he goes outside the scope of his employment, he's a third party.
No, not at all. He's still, as the court pointed out, he's still driving the bus. He's still wearing the uniform. He got back on the bus and continued to drive the bus.
Okay.
He is acting as an MBTA employee at the time, not
Now,
a very
now
good
wait a
MBTA
minute.
employee.
I'm trying to sort this out. You're not saying, you're saying agency principles don't apply here.
It's not what we're talking about, Judge. He works for the MBTA.
He works for the MBTA, I
On
agree.
behalf of the MBTA. And
Okay.
they're liable for putting him in the position.
No, you're talking about the merits there. I want to understand why the act is not a third-party act that they failed to prevent, but a first-party act by the MBTA.
Because if that were true, the MBTA could never be responsible for anything that their employees do. If
Because
that's true.
if it's wrongful, it's always outside the scope.
They're just going to say he was on a lark, he was doing something illegal, he was not acting in compliance with his employment. I'm immune. That's what the MBTA is trying to say. That is not the purpose of this statute. The purpose of this statute is to prevent the MBTA from being held liable when someone else does something wrong, and it happens and it occurs in an MBTA situation. It's not for when the employee gets off the bus, chases the man around the bus, and kicks his skull in, fracturing it, causing him to be permanently brain injured, and losing his job as a professor at a local college and having to live on the benevolence of his friends and families for the rest of his life. That is not what this statute is designed to do.
Were the lifeguards, were the lifeguards?
That's an interesting case, Judge. That's the Jacome case. The finding in that case was that it wasn't because the lifeguards didn't try to save the child. It was that the child drowned because of ocean conditions. It had nothing to...
The lifeguards weren't there, right? They had left
That was the
early.
finding, and that's consistent with how we view the statute to be interpreted. And I would point out that every case that I've seen in their brief relies upon the acts of other people. They're not talking about employees. All the cases that talk about employees are in our favor, and we've cited those in our brief. And I didn't see any cases that they cited that support their position. So it's our view that 10J simply doesn't apply to this case. And I'd like to mention a couple of other things.
For that to work, I mean, you have to make him be, it has to be, you have to say it's originally caused by the public employer or any other person acting on behalf of the public employer. And it's different from 2, which says acting, which has within the scope. So in Section 2, it talks about within the scope. Here, 10J, it talks about acting on behalf. Is there a difference between acting
I don't know
in
how you
scope
can
and
view
acting
Derek Smith to be doing anything other than acting on the behalf, but I don't view that to
Wait,
be part of the...
is he the public employer?
No, he's the public employee. The employer, and I go back to this, Judge...
How does an employer act except through its employees?
The
MBTA is whatever, some kind of weirdly chartered corporation. It can't punch someone or drive a bus off the road. It doesn't do anything. Except its employees do.
Quite to the contrary, Judge. The MBTA did quite a lot in this case. They continued, every time they affirmatively promoted him.
Okay, wait. Who actually promoted him?
The people at the MBTA.
Are those people employees?
Yes.
Okay.
Well, the MBTA...
But I think they're the MBTA itself.
A body politic.
I think that agencies act through the people who they're employed by. That's the only way they can act.
Certainly, Judge.
So I'm just trying to figure out, when it says someone acting on behalf of the public employer, I feel like that might be a non-employee too. I feel like the way the MBTA acts is through its employees. But maybe I've got that wrong. I don't see any case law on any of this, actually.
I don't know how to address that other than to say this, Judge. It's certainly true that the MBTA as an entity can't act other than through its employees. The actions that we view, which were negligent in this case, are the actions of retaining, promoting, and advancing Mr. Smith. As an aside, the 30 points, the 30 additional facts, those are out of the personnel records. Those are out of Mr. Epps' expert opinion, which are part of the appendix elsewhere. And the 9A issue, a wise judge, when I was first practicing many, many years ago, told me to sit down and shut up when I won the argument. So when we were winning that argument and things were going the way we didn't want to do a rebuttal about the 9A. The truth is, there have been a lot of procedural anomalies in this case, throughout the history of the case. And we're here where we are now.
Can I ask you about a procedural anomaly? You present yourself as the cross-appellant. What are you cross-appealing?
We don't believe that 10J should be involved in the case at all. So although the judge in the trial court found in our favor on the 10J argument, we don't think it should be part of the case.
So you think that the reason this can go forward is not because Smith is the original cause of the injury. You think we don't even go to 10J because that's only at issue when there's a third party.
Right.
I see. And in a doctrine of present execution case where one side gets to appeal because of the immediate effect of the order, which is them losing their alleged immunity, can you have a cross appeal by a party that doesn't?
To be honest with you, Judge, I don't really know. I just felt compelled to make the argument. And the other part of the cross appeal that I made here was with respect to the Bergeron incident. Okay, I don't want to go into it in great detail, but this was not just an incident where he had a fight with a guy on the bus. He got up out of his seat while the bus was moving and slammed into 3 cars. The investigative material that you have seems to suggest that the material that was released by the MBTA in explanation of this incident didn't include Mr. Bergeron's position in it. And that's why we were suggesting there was some sort of nefarious activity by the MBTA.
Now, that happened after this incident.
It happened before the incident, but after he was promoted to full-time employment.
Is being promoted an essential part of your merits case?
I don't know that it's essential, Judge, but it's important because if you think about the idea of the act by the MBTA in promoting him and retaining him, putting him on full-time puts him on more permanent routes. He certainly wouldn't have been on the Lynn route on a permanent basis if he was not promoted.
But this is not the 10J argument.
Right.
It is not part of what's in front of us. It's on the merits of your negligence claim.
Yes, Judge.
All right. And 10J is all that's before us.
I guess.
Well, in terms of present execution, what issue is?
That's my understanding of it, Judge. But so I kind of am in the position, it's an odd position for me to be in, actually, because I just want to get to trial, all right? This has been 7 years of my client's life in a living hell. All he wants to do is get to trial. If I have to get to trial and I have to deal with the 10J issue at trial, I'll deal with it at trial, okay? I don't think it's part of the case. But I'm happy to have the judgment of the lower court affirmed on the basis that the judge affirmed it so I can get to trial. It puts me in the odd position of having that cross appeal when I don't know that it's in my best interest to even do so.
So there's a tension here. I mean, here's the tension, is that this is an intentional tort on behalf of Smith, right? It's an intentional tort. It's assault and battery. And so to get around that, you have to allege that it was the MBTA's negligent retaining, promoting. But then you're getting into the area of failing to prevent an act. I mean,
I don't think the tension is as acute as Your Honor may indicate. The claim against Smith, obviously, is for his intentional tort, but there's also a negligence claim against him. He's a defendant in default. No one's ever going to collect any money from him. He's been fired. I don't know where he is. He's gone. The claim against the MBTA, however, is a negligence case. And it really, the act, so to speak, doesn't really matter as much as what the MBTA did, in our view, what the MBTA did to promote and retain and not discipline this dangerous individual. And I'll note, every one of these incidents that we've enumerated in our briefs, by the MBTA's own rules, require discipline and could or should have been fired for many of them, certainly for the Bergeron one. Their own rules they didn't comply with. So how they can allege that it's not a negligent act to continue to promote him, advance him, and retain him is beyond me.
But that's on the merits. The 10J question starts with, is this a condition caused by a third party? Right? Is Smith a third party?
We don't believe he is.
No, I understand that. But that's all we're talking about, right? It's not about the hiring or whatever. That's the claim.
And at its essence, Judge, that calls for a determination of fact.
Why did you bring it as a vicarious liability case first?
The original claim included vicarious liability. The notice letter was deemed to be insufficient to provide notice to the MBTA on that grounds. So we modified the claim. And
Well, you couldn't bring it under 10C.
Pardon me?
You can't bring a vicarious liability for an intentional tort under 10C.
Regardless, Judge, that's the reason it's not part of the case, and we were barred from bringing it
The
back.
judge did not reach the question of whether 10C barred this, that claim?
No, I think the judge did.
Okay.
Wasn't 10C? I'm sorry, I may have misspoken.
Okay.
But you say it was dismissed for lack of presentment.
The presentment letter. But the point is that the defendant in the case, and the target defendant in the case, has always been the MBTA for the reasons that we've cited in our brief, for what they did and in terms of elevating and promoting who they knew to be. It's not whether they should have known. They absolutely knew how dangerous this man was. And yet they put him in a position of public trust and safety, putting the public at risk, and unfortunately, resulting in severe injury to my client. There are no other questions. I'll rely on the balance of our brief.
Judge? No. I see no further questions. Thank you.
Thank you, Justice.
Excellent argument by all of you. Thank you very much. The case is submitted, which brings us to the end of our sitting for today. I would like to thank the court staff, and in particular, the court officer, for their excellent work today, and we stand in recess.
Court is now in recess.